Welcome, 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 ladies and gentlemen. Welcome to Kitchen Court Cases, where we watch court in my kitchen. Today has been quite the day in court. I spend my days toiling away in the mines that are the United States court system. And in doing so, I search for the gold. I search for the diamonds. I search for the extra special nuggets that I know you will all love. And I have found some for us. So, welcome if you're new here. If you aren't new here, you know how it goes. I'm so happy to see you. Is my audio okay? Tell me in the chat if my audio's okay. We have many different things to watch today. Bob Dobbs, thank you so much. Thank you, thank you, thank you. And Laura, I don't actually have quick access to PayPal, but I believe you. So thank you, Laura, Laura, Laura. Thank you all so much. I appreciate it. Seriously, let's see here. The alert should be coming soon. I love the alert, you know it. So let's just wait for that momentarily. I'm so glad you're all here. If you're new here, let me know what you've had for dinner, or not if you're new here. If you're new here, what I always ask is what you had for dinner. If you didn't like what you had for dinner, go ahead and tell me what you wish you had for dinner. I love to hear what you're eating. I am, God, Streamy, you're so slow today. It's like, anyways, I haven't had dinner yet, but chef salad from Sashina.
Oh, yeah.
Thank you, Bob. And then we'll do an extra one. I will do this for Miss Laura. Thank you.
Oh, yeah.
That's just a tester, but you get the oh yeah. So thank you guys, seriously. I really do appreciate it. You know that. Now, what I literally just muted myself. I was like, and no. Anyways, what we have tonight is a collection of different things. Listen, obviously time served got the best cleave shot of the day, right? Because we saw that in his thing today. But I myself was able to collect some great clips. We are going to start off in Judge Mark Bronlick's personal meeting room. I got some cleave, arbitrary hubris. I'm not I mine hard for that stuff. But seriously, we're gonna start over with Judge Bronlick. Judge Bronlick, no nonsense. And this is an interesting hearing. I think you'll figure out why I think so. It's based on the attitude of one of the participants. So let's get that started. Also, if you're new here, you got to clock in for your shift. That's how we do it. Clocking in for your shift, you hit that like button or the dislike button, whichever you prefer. And once you've done that, that's good. You'll notice there's stuff going on in the chat. If you don't like to see Streamlabs and people gambling and all that kind of stuff having fun, go ahead and block Streamlabs. But if you want to participate, just ask away in the chat. So, like I said, Judge Bronlick's personal meeting room, and let's see what we've got.
Second, he motioned up a motion to withdraw on May 8th, but we didn't deal with it at that time. I don't know, what does the ROA say? Do we, they haven't appeared.
Hello in Scotland. That's great to hear. I was born in Scotland. Also, you guys, I don't like to make fun of people's names. I don't. I personally, we've all talked about this. My name is my name. But this girl's name is unique. This is September. We have September. And I actually like that name. Like, that's not half bad. I mean, it would get confusing in September. But other than that, you'd probably be fine.
Proceed, please.
I'm here. It kicked me out.
I just want to see corporate reserve all outstanding issues.
See, that's not in the court file. That was a month ago, wasn't it? That was 40, so it's in the court file. See it. You
Are you
ready?
Mr. Stevens?
Yes, ma'am.
Okay.
Okay, court is now in session. September Stevenson versus Dakota Stevenson.
For the record, this matter is before the court for continued pretrial conference subsequent to mediation. This hearing is being conducted via Zoom. Present is attorney Teresa Reiser representing the plaintiff. September Stevenson. Ms. Stevenson is present. In addition, Attorney Scott Musson is present representing the defendant Dakota Stevenson. Mr. Stevenson is present, as well as our mediator, Mr. Prad. It's a pretty quick mediation. It was set 1:30. It's not even 1:50 yet. Why are the parties not mediating? Mr. Musson, Ms. Reiser?
We're prepared to go with Miss Stevenson's prepared to mediate.
Okay.
Mr. Stevenson is asking for a 2-week extension so he can find alternate counsel. I was in a bit of a difficult position, so I was explaining to Mr. Pratt that Mr. Stevenson has terminated my services. He's refused any other work. My instructions were don't do anything further on this case. I have not spoken with Mr. Stevenson other than to mail him the notices and the domestic violence screening forms for the mediation. Which I did do that, but outside of that, I have not spoken with him since the last court hearing. And after that last court hearing, we had I would just say a fairly heated conversation. That it was very, very clear. I had originally thought maybe we could work this out, but the second conversation I had was a little on the abusive side and not something that
This is my attorney, though. This is my attorney talking on me.
Continue to represent Mr.
This is my attorney that is
So we have
talking on
Hold
me.
on,
a
Mr.
serious
Stevenson,
breakdown.
Mr. Stevenson, hold on. The court cannot hear two people talking at the same time, Mr. Stevenson. So just let Mr. Musson finish. I can't hear you when you're talking over Mr. Musson. So please. Mr. Musson, you previously filed a motion to withdraw. That was set for hearing on May 8th. Apparently, we passed that. You were hoping to continue to represent Mr. Stevenson, but you're renewing your motion at this time?
Yes, Your Honor.
All right.
The attorney-client relationship is broken down.
Right. Mr. Stevenson, do you have any objection to Mr. Musson withdrawing as your attorney?
No, I do not. He has not done one thing for me.
So
sir.
ordered. Mr. Musson, please submit an order to the court. Mr. Musson? Mr. Musson, can you hear the court?
Mr. Musson is creep framed. Oh gosh. So let's just do a quick little recap if you're just joining us. We are watching in Judge Bromlich's room right now. We have September down here in the middle at the bottom and Dakota. They were supposed to be in a mediation, but it looks like Dakota went ahead and fired his attorney, Mr. Musson. Judge Bromlich is not impressed with this. And this is when I was like tuning in and I was like, oh yeah, I need to know what's happening with these people. So we will see the end, most of the resolution of this situation, just so you know, which is great. But he's not happy with his attorney right now. He's not happy. Also, hi guys. Hi to anybody new that's just joining us. If you are new to the lives, welcome. And yeah, let's get going.
Okay. I will.
Please submit an order to the court.
Yes, I can.
Okay. All right.
All right.
Oh, Hyper Nikki has made a good point. I just want to point this out. It's not quite enough to have a lawyer, okay? Because as we can see here, and I have many examples of, if you don't allow your lawyer to lawyer, you're going to be screwed. So again, most imperative is not only hiring that attorney, but then letting them be an attorney. It is very difficult for people to just allow that to happen. It's hard. But let's continue. Let's see where Judge Bromlick takes this and where Dakota ends up.
Listen, all right, Ms. Russell, you can zoom out.
All right.
All right, Mr. Stevenson,
Thank you, Your Honor.
this has been scheduled for a month now.
Yes,
You're
sir.
wasting Attorney Reiser's
not.
time. Mr.
Sir.
Stevenson, just listen for a minute, please.
Yes, sir.
The Attorney Reiser is here at the expense of Ms. Stevenson. Mr. Pratt is here. She's blocked off half a day to mediate. This is not a binding process. What is the harm in talking? The only issues I understand are custody and parenting time. Is that correct?
Yes, sir. And I am willing to agree to, like I told Ms. LaPrada and Mr. Mustin, I'm willing to agree with September on everything. My kids need established set time. I will agree to that, but I want to go in front of, so I would take this in front of somebody. I want to see what they're actually offering me. Mr. Mustin has not sent me nothing. He went on vacation at the end of May and he didn't talk to me for 2 months.
Okay, all right. So at this time, two things, Mr. Stevenson. I want you to find a place to sit down rather than walking around.
Yes, sir.
Sit down, and I want you to talk. Give it at least the 30 minutes to talk with Ms. Stevenson. The reality is, you as parents know what's best for your children. But if you can't decide, the court will make the decision. I'm sure it'll be a decision neither one of you like. So talk. Maybe they're not that far apart. Let's try. And if you can't, then we'll come out and we'll set up for a hearing. The court will decide these matters. You can hire an attorney for that hearing. But this is not binding. Just keep an open mind in terms of there's enough challenges in life. Don't make things more difficult for you, Ms. Stevenson, or the children. So I'm going to have you talk with Ms. LaPrade. Hold on, Mr. Stevenson. Will you stop interrupting the court, please? That's your problem, is you can't listen to anyone.
Nobody's hearing me.
I am.
No, nobody's hearing me. These are due to my children. I love my children with all of my heart. Nobody has listened to me since day one. I've been trying to tell you that he was withdrawing the last time. You were the one that told me that he was withdrawing off my case. I had no knowledge of this, sir. I hired him. No, he did not send me nothing. I had hired him through a law firm online, and that's who they referred me. That's who they gave me. I am in contact with Marble Law about what is going on. I haven't just been sitting here sail whale for the last month. I've been contacting them nonstop, sir.
Okay, we're past that point. We're past that point. Mr. Mustin's out of the case, so we're past that point. Let's move forward rather than dwell on what in the past. The court will sign an order. Mr. Mustin is removed as your attorney of record. I want you to talk. You at least give 30 minutes to talk with Mr. Pratt. I'm sure she'll hear you out. See if you can agree. Ms. Reiser, do you believe that to be the only issue? Parenting time and custody of the two children?
I believe, yes. If we can resolve custody and parenting time, I believe we can put it to bed.
Well, and again, I think the parties put too much emphasis on physical custody. Let's focus on hopefully they communicate, they agree upon joint custody. It's just a matter of parenting time. So, Mr. Stevenson, I want you to at least talk. Keep in mind, this is not binding. It's not a trial date. Mr. LaPrade can make a recommendation. After she give it a try to at least talk. Are you willing to talk this afternoon?
I'm more than willing to talk. She hasn't agreed to me, and everything I've said to my attorney, he hasn't even addressed it to them.
We're gonna have to roll that back here just a moment. Did he say I'm more than willing to talk? She just won't agree. Yeah, that's not talking. Not winning doesn't. That's nobody. No.
So, Mr. Stevenson, I want you to at least talk. Keep in mind, this is not binding. It's not a trial date. Mr. LaPrade can make a recommendation. After she give it a try to at least talk. Are you willing to talk this afternoon?
I'm more than willing to talk. She hasn't agreed to me, and everything I've said to my attorney, he hasn't even addressed it to them.
Okay.
It's been 8 months, Your Honor. I'm over this too. This is the stress of my life. It's causing me medical issues. It's causing me a lot of issues.
Yeah, we don't want that. So I'm going to have you talk back with Mr. LaPrade.
Thank you.
I'm going to have you talk back with Mr. LaPrade and keep an open mind, both of you. Mr. Pratt, can you talk to them maybe 30 minutes? If it's unproductive, just come back out and we'll set a hearing.
Yes, sir.
Thank you, ma'am.
Thank you.
Thank you.
So I was like, okay, they're going to make him go in there now. I've got to pay attention. Well, here's some truth factor for you. Okay, this is what my screen recording folder looks like. I'll just scroll real fast. But just today, we have a lot, but I believe it's this one. So let's see how Dakota did. Now, first of all, I want you to just remember, I think we have to give an applause when we do find parents that are willing to work with each other, even when one isn't. We will see here, September is very reasonable, in my opinion.
This is the second time.
Oh, shoot. Now I remember what happened. Okay, I'm going to have to get Larry Beaver out
Device.
because there's their kids on
I'm
screen. I don't want
renaming
to show them.
Dakota's device so it doesn't say iPhone. There you go.
How do I do that? This is the second time.
There should be dots there where you can rename yourself, but we can do it on our end too. So we just changed it. You're fine.
Okay, thank you.
If you're new here, guys, this is Larry Beaver. He is my Beaver buffer dam that I use when there are things on screen that shouldn't be shown because of whatever reason. Although it's not our normal buffer, I just try, you know? And I was gonna skip past this, but again, I really like the stuff that happened.
She's right there. Tell me right there, I love her. She's right there.
Say hi, Dad.
Hi, boogers. How are you, beautiful? Hi. You being good for mama?
Always.
Where's your sissy at?
She's a good girl. She's in there playing.
I love you, Amira. Daddy loves you, baby.
He loves you.
You ain't got a dress on right now?
She literally just took it off like 2 minutes ago. You know how she is with her dresses.
Where's her hair?
She's right here. Mimi, you want the tablet?
Let's see her hair before they come back.
Want the games? All right, I'm gonna give it to Sissy then.
Let me see sister before.
Mayor, thank you so much.
But
Hi, baby. Hi, beautiful. How are you doing, mama?
go back on
Oh,
court.
yeah.
Court is now in session, recalling September Stevenson versus Dakota Stevenson.
It's certainly music to the court's ears when the two of you can communicate as parents
Oh,
and
yeah.
acknowledge your beautiful daughter.
Thank you so much, Mayor. Look at all these new crew members becoming part of the KCC family. I know Larry just failed there. It's okay. Going in his file, by the way. Seriously, thank you so much, Mayor. Welcome to everybody. Remember to clock in for your shift. Please hit that like or dislike. I'm going to keep playing it in a second. I'm just going to let the oh yeahs really sink in.
Oh, yeah.
Because I think, well, I don't know, Lisa. Larry and I are both Canadians, right? So, if you just missed what the judge said here, though, I really appreciate it, and it's nice. Let's listen.
Stevenson versus Dakota Stevenson.
It's certainly music to the court's ears when the two of you can communicate as parents and acknowledge your beautiful daughter.
Gorgeous, huh?
In any event, the parties
Both of them.
have conferred with Ms. LaPrade and apparently have reached agreement regarding custody and parenting time. Is that correct, Ms. LaPrade?
That's correct, Your Honor.
The court's informed there's just a couple of small issues which the court will address after put the agreement upon the record. There's an issue of a personal property division or a walkthrough and examination as well as a dog. But if we could perhaps put in the record, Mr. Pratt, would you understand the parties' agreement regarding custody and parenting time?
Yes, sir, I can do that. The parties are going to share joint legal custody of their 2 minor children. And father will have every other weekend, Friday after school or 3 p.m. when no school, until Monday at school or 3 p.m. if no school. The parties will be transporting the minor children to the Romulus Police Station, and that will be inside the Romulus Police Station, and any third party that's licensed and known to the children may transport, but father needs to be the one to do the exchange within the police department. Mother will make sure that father has all information for all medical providers and specialists for both of the children. Neither party will post social media posts regarding the other parent. The parties will continue to communicate via app close. The parties request a review of parenting time the end of August to see how things are going with the minor children.
Oh,
As far as the property the parties did agree to, they are going to be closing a joint bank account. That account has no money in it, so there's no division. The parties do not own real estate. The parties do not have any retirement accounts. And each party will keep any debt, any bank account, or any vehicle in their own name. And spousal support would be barred as to both. It's a short-term marriage, Your Honor, of 5 years.
Thank you. Ms. Rice.
Just before we go on, I would like to point out, first of all, Donna, thank you so much. Orlando Chiquita, my dear friend, thank you so much. But what I want to point out is about another video that I posted this week. It was entitled something like, "Please Judge, Stop My Spousal Support." That's what it was. "Please Judge, Stop My Spousal Support." And see, it's weird. I remember numbers, but I don't remember. Well, whatever. So the woman made 60K, the guy made like 92K, and he was paying spousal support. The marriage was only 5 years. And I was like a little like, that's a short-term marriage normally. It was very odd to me that that spousal support order was put in place in that case. Now, obviously, this is not the same court, not the same situation, but the way that she just said that, a short court or a short marriage and therefore no spousal, it's so interesting how each case is, I guess, obviously different, but my brain says that. I'm really glad they started to work this out. I'm really mad that, well, you'll see what happens. Mark Demeline, he has reminded me with his wonderful 420 donation. Let me know what strain you've got in your brain today. What do I have? It's right in front of me. What is it called?
Oh, yeah.
Oh, I've got the Mountain Kush right now. Thank you again, Mark. All right, let's continue.
Is that a correct statement of your client's agreement?
You're muted, Miss Reiser.
Sorry about that. It is, I'd like to add a few other things they agreed to. They agreed that no third parties would be allowed to communicate on app close. App close is only for the parties. I believe they're already exercising holiday parenting time per the Monroe County guidelines. And the last thing is the review in August. It was, I believe, contingent upon dad obtaining a valid driver's license.
The review is contingent upon him obtaining a valid license?
The determination of expanding dad's parenting time would be
Oh,
based on whether or not he has
Okay.
a valid driver's license. We didn't want to just
Okay.
let it go. We set a review date for the future, but the purpose is to If dad wants to expand his parenting time and transport the children to and from school, he needs to have a valid license, basically.
Okay, all right. So hopefully, Mr. Stevenson, you can get that straightened out. Do you know what you need to do to get your license straightened out?
I already have an appointment at the Secretary of State in Inkster. I've been trying to get it.
Good.
It took me, it's like 2 weeks. They had it set out.
Okay.
And then I had to get my social security card and my birth certificate. And now I got everything. So I'll have my.
Wonderful. You're moving in the right direction because we want to make things easy and we want to expand your parenting time. So hopefully you'll have that license when you come back.
I will, sir.
Okay. So the parties will communicate only via app close and only regarding the children. Is that correct?
Yes.
Yes, sir.
Okay. All right. Mr. Stevenson, is that a correct statement of your agreement?
Yeah, I agreed to all that. I'll agree to everything besides the dogs and
All right, we'll get to that.
Her coming to my house because she's already filed to be
Okay, hold on. We'll get to that.
Okay.
Let's at least focus on what we agreed upon. So we agreed that two of you shall share joint legal custody. That means both of you share equally regarding a major decision concerning the welfare of the children,
Yes, sir.
medical appointments, health decisions, education. So obviously, Ms. Stevenson, you need to make sure dad's listed on any contact forms with the dentist, the doctors, pediatricians. You need to inform him of any appointments. If he chooses to
Yes, I do.
appear or make inquiry, so make sure you do that.
He is informed every step of the way.
Okay, and when will this parenting time start for dad? Will it start which weekend?
They already exercise alternate weeks from Friday to Sunday, so we'll just make it
Continue.
longer.
All right.
just be next weekend. It's been the same. It's been the same.
We'll exchange at the Romulus Police Department, and you want to review date sometime in August. Is that correct, Ms. Reiser? Or we can
Yes.
you can put that right into any judgment. The court took the proofs back on May 8th, 2023. So the court's established jurisdiction that it's going to break down. We'll give you a proposed date in August. We have August 22nd, 23rd, or 29th. Obviously, we'll make sure Mr. Stevenson has plenty of time to get his license straightened out. So would you prefer early, mid-August or late August?
Late August, just so I know I got it.
Okay.
I'm cool with everything that's established right now. So until August, that's fine. I'll get my.
Okay.
It gives me time.
How about August 29th, Ms. Reiser? August 29th at 8:30 or 1:30?
That works for me, either one.
We do
Which one
1:30.
do you prefer? Mr. Stevenson, would you prefer 8:30 in the morning or 1:30? It'll be a Zoom hearing.
Can we do 1:30? Just
Sure.
so it's later in the
Okay.
afternoon. I make sure everything's good.
Yeah. Okay, so you can put in a judgment, Mr. Reiser, the court will review dad's parenting time, August 29th, 2023 at 1:30 p.m. via Zoom. You can actually include the court's Zoom ID number in that judgment.
What time did you say that was again? It was at 1:30?
1:30.
1:30.
1:30.
August 29th. Thank you.
Okay. Ms. Reiser is going to prepare a proposed judgment of divorce. She's going to put that in the judgment, the date and the time, the Zoom ID number, Mr. Stevenson.
So how am I going to get that? I don't have Mr. Musson no more. So how do I get, is it just the same Zoom ID?
Correct. Same way as Zoom
Okay.
ID number. She's going to put in the judgment. You'll be able to copy his judgment. All right.
I have it here as well, Dakota.
Right,
So
Miss-
if you need it, I can send it to you.
Yeah, just
Mr.
send me an
Stevenson,
app.
could you both raise your right hand to be sworn? Do you both solemnly swear affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
I do.
All right, Mr. Stevenson, could you state your name and current address for the record?
Dakota Daniel Stevenson,
Blah, 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 blah,
4705
blah, blah, blah,
Jackson
blah,
Street,
blah, blah,
Dearborn
blah.
Heights, Michigan. 48125.
Capture that address.
Yes, Dearborn.
48125.
Mr. Stevenson, the agreement that's been stated on the record regarding custody and parenting time, and going, they're always subject to change. As circumstances change, we can always modify parenting time upon a change of circumstances. At this point in time, do you believe this agreement to be in the best interest of your two children?
Yes.
Okay. Do you have any questions of the court or any questions of Ms. LaPrade?
No, I'm just ready for the divorce and everything to be finalized.
Okay.
There are 2 stipulations on there. That if we come up with between here in August, I believe, if that's what we're doing. I placed the dogs due to her.
Hold on, we'll get to that. We'll get to that. Let's do customary time. And obviously, Ms. Rice, she's putting the judgment that the holidays as agreed, if it cannot agree on holidays, then the fallback will be the Monroe County Friends Court holiday schedule.
Yes.
She's been good with
So
this
I'll
holiday.
put Macomb County, yes, and I wanted to mention,
Bro.
she does want to go back to her maiden name. I'll put that in the judgment as well.
Okay, and this is Monroe, not Macomb County.
She's been
Oh, I'm
pretty good
sorry.
with the
Sorry, I'm
holidays.
sorry.
I don't have a complaint about that.
I get my ends mixed up here.
All right, can you listen to some brief testimony, Ms. Reiser, from Ms. Stevenson in terms of this arrangement that she believes to be in best interest of the two children at this point in time, please?
Yes. Ms. Stevenson, did you hear the custody and parenting time and the partial property settlement agreement that was placed on the record?
Yes,
And do you believe that the custody and parenting time arrangement is in your children's best interest?
yes,
Okay, and do you believe that partial property settlement that was placed on the record is fair and equitable?
yes.
That's no further questions. Oh, are you
Thank
pregnant?
Ms. Reiser.
No,
Okay.
Thank you, Ms. Reiser, for updating that proof. Okay, there are two other issues. One has to do with some personal property. The court is informed, and just listen, Mr. Stevenson, please don't interrupt. The court's informed that one of the issues that Ms. Stevenson wants to walk through the house. Is that correct, Ms. Reiser?
Correct, Your Honor. She believes she left some clothes and books and personal documents
Okay.
in the home.
Okay, Mr. Stevenson, are there any of Ms. Stevenson's clothing or books, or
No.
personal items in the home?
No, there was a bookshelf of my kids' books that didn't have. I looked for her school books. There's nothing in here. She came in my house and she had a police escort.
Okay, hold on. We don't, Mr. Stevenson, we don't need to get into a whole long. I'm just
saying
asking
that
you,
she's already-
do
no,
you know of any of her items in your
nothing.
home?
There's nothing. It's only me, my girlfriend, and her child stuff in my home. She did a walkthrough already, and she got it all out with the police, the Dearborn Heights police.
All right. So Ms.
We have the
Stevenson doesn't
video.
want anything from hold on, Mr. Stevenson, please.
Yes, sir.
Let's get through this. Ms. Reiser, Ms. Stevenson only wants those limited items from the home. Now, if Mr. Stevenson says they're not there, how is she going to find those? I don't want to create a scenario where we're going to have an altercation between the parties unnecessarily.
I
Does
guess
Ms.
I
Stevenson
would,
know where they at? Are they in a box? Do they have a name on them? Are they in the basement? Are they in the shed? Are they in a storage facility? Where does Ms. Stevenson believe they are?
I believe that it's an apartment. Is it an apartment?
no,
it
it was,
hold on,
it was
hold
a
on.
house, but we
So-
moved everything over to the new house when we moved. And my daughter had a bookshelf that that Dakota's mother actually provided a lot of books, but I also had my school books there as well as in boxes. So, he threw them away or they're there. I did not bring them.
There's the
Okay.
bookshelf. No books. I don't have no books.
What happened to
Is
the
that the
book?
bookshelf?
She took every single one of the books. She took everything out of the house.
First of all, it's not exactly a great flex to be like, I got no books. Not a book to be found in this house, Your Honor. Also, she looks really confused. I don't think she took all the books. If you look at her face, she doesn't look like she's faking it here. Let's go back as he says this. Watch her face.
I did not bring them.
There's the
Okay.
bookshelf. No books. I don't have no books.
What happened
Is
to the
that the bookshelf?
She took every single one of the books. She took everything out of the house. The day that she came over here with the police, she took everything out. The police had her walk through my home and they said that she will not be able to come back. She filed to get her name off of my lease, and that was stating that she was no longer had nothing in my
Okay,
house.
all right,
She was
Mr. Stevenson,
$1,500.
hold on, sir. Hold
sir.
on, relax, take a deep breath, will ya? Just trying to determine if there's anything there, and you're saying there's nothing there. So Ms. Reiser, I'm not sure what we're going to accomplish. If in fact she wanted some things for the home, she wanted some wall hangings, if she wanted that, I would allow permitted walkthrough. Somebody's got to pay for law enforcement. But at this point in time, if she says she wants her clothing and books, and Mr. Stevenson says there's not there, obviously whether someone disposed of them, whether she took them, I don't know. But he's saying they're not there. So what purpose are we going to serve by her going through the home?
I guess the question would be, where did they go? I mean, she wants to go back she's going back to school and she wants her textbooks. They're expensive. She also
Right.
did say that she'd like half of the kids' toys.
She already took them. She already took all of my kids' toys. Every toy that's here. September, show them your living room and then show them mine. She's taken
Right.
more than half of all my things.
Okay,
She's-
all right.
I have toys that I provided.
Kids' toys can be replaced, so we're not gonna get into kids' toys, those belong to the children.
Which I've replaced
And
them
yeah,
already.
some of those, Mr.
Down to
Stevenson, if
12.
some of those, Mr. Stevenson, if some of those
Yes.
toys are special children, you should let them take them to mom's house.
Sure,
If you're gonna do it
I
with
provide
that.
them with everything. If it's at my
All
house
right.
and I buy it, I give them it. It's their toys.
Okay,
If my
hold
daughters
on. So
want it,
obviously, Mr. Stevenson, relax, take a deep breath. If Miss Stevenson has a school textbook, so ours are expensive,
I
they're
would
no.
give-
And that is what my life is like. We live and die by the record button and the video unavailable. Honestly, I was lulled. Judge Bronlick often leaves his stuff up and I can download it. This one I was grabbing because I didn't want to miss it, but I didn't grab it at 2x speed. I was doing it at 1x speed. Frustrating, right? Where do I find all these great videos, Vicky? Well, I sub to like 1,000+ courts that I look at all the time. I have an obsession. It's probably considered unhealthy by a lot of people. Let's think. What did I promise in the what did I oh and in my downloads too. But what did I promise in my I think I promised a TPO. The stalking one. I was mildly interested too, man. I was upset. Let me just check this and see which it is. Okay. This is good. This is good. Is this? No. No, this is not. Oh my God. That's not the first part of that case. The first part of that case would be. Sorry, guys. We are doing a TPO. It's not going to be as shocking as last night at all, so don't worry about that. It's this one.
Witnesses are.
No, not that one. That is one, but that's not the one I'm looking. Do, 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 do. This is it. Here we go. This is crazy. These people not. This one I always get in 2x because they always delete immediately. These people and I have they feel like my personal enemies in the YouTube world, the way that they pull these down so fast. I hate, but I love you.
There we go. Good afternoon, everyone. We've been going nonstop since the calendar started this morning. And I understand y'all were able to speak with the facilitator and unable to reach an agreement. I do appreciate your efforts to do so. At this time, we will have the hearing. I'm just reiterating to everyone who is participating or viewing anywhere or out on the World Wide Web that any unauthorized recordings are strictly prohibited of these proceedings, and I have not authorized anyone, so no one is authorized to make any recordings of this, and any willful unauthorized recordings can result in criminal contempt consequences for those involved. At this point, we will have a hearing in this case. This is case number 23 PO 4637, Stephanie Dawn Trans versus Kylan Michenet. The family violence petition was filed on May 11th of this year. And an ex parte order was issued and served upon the respondent on May 19th of this year by law enforcement. And so we are at this time going to have the hearing. Just a few pieces of information for the parties. Once I will swear both parties in, and then once the hearing starts, the petitioner goes first because she has the burden of proof under the law. on whether there has been an act of family violence committed and whether there is a reasonable likelihood of future acts of family violence being committed. So those are both things I have to consider, and there are various legal definitions involved with all of that. So first, the petitioner will go forward. The respondent will have a chance once she is done presenting any testimony and evidence. The respondent will have a chance to ask me, there won't be any direct one-on-one, but ask me any questions about what was testified to factually that she would like me to ask the petitioner. And or she will have the opportunity to, some people ask questions, some just testify when it's their turn, to give any information that they want the court to know. Once the respondent has done is finished.
That was a great question from Rodrigo Munoz. Dude, I took 4 years of Spanish. I still can't pronounce it. He says, switching court cases. If you had to go to court for recording, I assume you mean if I had to appear in front of a court for a contempt charge because I recorded, which YouTuber would you like to stream and comment on my case? Oh, first of all, okay, weirdly, the behavior panel, so bad. I would love that. I just really need an assessment, a full assessment done, and that seems to be the cheapest way to get that done. But no, seriously, I want all of them. I would want my court clip to be so epic that it was covered by every YouTube law tuber. Mostly, I just want them to analyze me. I just like being analyzed. That's really it. But in reality, if you don't know, I'm Canadian. I live in Canada. I'm an immigrant to Canada. I was born in Scotland. So the likelihood of me being brought before a court for a contempt charge for this type of behavior, while not non-existent, is slim. And I already have a few arrangements made. It's an implicit arrangement with you that y'all will bail me out. Okay? That's just the implicit arrangement we have here. Canadians do have jail. I will read a funny story after that about Canadians going to jail for acting like Americans. Let's put it that way.
Testifying, the petitioner will then have a chance to ask me any factual questions. It's not the time for testimony. It's the time to ask specific questions about what was testified to ask any questions she would like me to ask the respondent about what was testified to. And then once both parties are finished with any testimony and evidence, I will make a conclusion as whether the burden has been met to warrant an extension of the order. Okay. Additionally, this is not a forum to resolve any landlord-tenant disputes. It is solely whether there is a need for temporary extreme intervention for family violence going forward. So that is what the court will be looking at. Also, one thing I do need to note, because I believe there may be, have either of the parties been arrested for any allegations going on in this case?
Yes, Your Honor. I was arrested for battery when I was.
Don't say anything else. Don't say anything else.
Okay.
I need to let you know that anything you say in these proceedings can and likely will be used against you in any future criminal proceedings.
Okay.
So you are strongly encouraged to speak with an attorney about that.
As the judge said that, I just had this realization. I was like, oh, there is hundreds of hours of me on camera doing this contempt of court. I don't care. I really don't. You guys know it. It's if the courts have time to process and deal with me having contempt of court because of this type of stuff, I want to be involved in that court system. I'd love to see what it's like from the inside.
You are proceeding pro se, so I need you to make sure you understand that anything you say in your testimony can be used against you in your criminal case.
Okay. I was arrested for battery because.
So I don't need you to tell me anything else about that. I need to make sure you understand that.
Okay, yes, I do.
Okay,
yes,
so there are criminal, and is there, let's see. All right, so that's I've let you know that. So when you make your decision to testify, you need to keep that in mind, okay?
Okay.
At this.
Also, the judge is sounding a little auto-tuned. Like I've said, these hearings are fleeting moments in YouTube history, and they are I have to record them in 2x. So until we catch up in speed, we won't the audio might be slightly like that. The photos are yikes, Credence and Mikey. By the way, guys, Credence and Mikey in the chat. I'm assuming that means the chase is over. I saw that alert come up on my phone. If you guys aren't following Credence and Mikey already, they are OGs and where I like to hang out during the day. Heist Hog Lives. I love you guys. I love all the heists. I love it all. Yeah, I don't know how to not make it auto-tune sounding, to be honest.
Point. I think that is everything I needed everyone to be aware of. So if both parties will please raise your right hands. Do you solemnly swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth under penalty of perjury? Miss Strantz?
Yes, I do, Your Honor.
All right, and Miss Michenet?
Yes.
And can you can lower your hands. And how do you pronounce your name, Miss Michenet?
Yes, that's correct.
Okay, well, I speak French, so I was leaning that way.
Parlez-vous français? And that's all I know. Shit. Even being Canadian, I do not speak very good French. I was thinking about this earlier. I have a funny feeling I will eat a whole French baguette if Judge Davis up there can speak fluent French. I imagine she took French class similar to how I took Spanish class. AKA, we took it. I don't know that we speak it, if you know what I'm saying. We. Okay, let's continue on.
All right. So at this point, what we will do, there's not going to be anybody talking over each other. I will let the petitioner let me know what she wants me to know about why she filed and why she is seeking this order. So you may proceed, Ms. Strantz. Or let me ask these questions. I need to ask a few questions first. So,
Okay.
Ms. Strantz, how do you know Ms. Michenet?
I live in a pad split where they rent rooms to people in a house. It's a company. And I've been living here for 11 months, and she was able to move in as another tenant in the room directly across from mine.
All right. And does she still live there now?
No, no, Your Honor.
Did you know her before she moved in?
No, Your Honor.
So when did she move in?
Beginning of May, perhaps. Maybe a little bit after the beginning of May.
Of this year?
Correct.
So how long was she there before you filed?
Not long at all. 2 weeks.
Two weeks?
Okay. And is your understanding that she is living in a different residence now for the future?
No, no, Your Honor, I don't know where she is. Don't want to know where she is. I don't even know her. She moved into this home. I'd never seen her before, and she was subsequently removed because of the TPO I put out against her because of the evidence that I showed Judge Cash.
So, and let me just, that was the one person presenting evidence and it was granted based on that, but this is the hearing where both sides have an opportunity to be heard. So it's a new hearing.
Okay.
So just to explain what the judge just explained there, in Georgia, sorry, I never introduced that. This hearing is being held in DeKalb County, Georgia, and this is a TPO hearing, temporary protective order. With temporary protective orders, there's an implicit understanding that the situation is both serious and time sensitive. And so there is a court procedure where the petitioner will be seen by a judge ex parte without the other party. They will they give the details of the case, and the judge then issues the ex parte TPO order. That order is valid for usually 30 days, and it is something that is totally enforceable as soon as the person has been served appropriately with that ex parte TPO. However, it is absolutely an ex parte TPO, which is understood to mean that the other person had no opportunity to defend themselves or present any evidence whatsoever. So when people say that they got a TPO, it's very important to understand if it was an ex parte TPO or what's happening here, which is an extension of an ex parte order into a 12-month protection order. Still considered temporary because most things within the court system are not in a permanent way, but because it's for protection, they do these very quickly at the beginning in ex parte fashion in order to give safety to people. So basically, and you'll remember this from the Depp v. Heard trial, which she had the TPO issued, but it was ex parte. And as soon as there was in front of the judge with the ability to present evidence, that TPO was not extended. And so, it really is not the same value to somebody until you've had it extended. So this hearing right now is that extension hearing. It is the time for the petitioner in the top right to go ahead and present her evidence as to why the ex parte order should be made into a longer standing order. And the judge is quick to break into that because you were issued an ex parte TPO is not a basis to be issued a 12-month order. That's not how it works. Again, the evidentiary standard of an ex parte hearing is very low because it understands, and not only that, but in fact by law has to be heard with both parties within 30 days. So there's a lower evidentiary threshold with the understanding that there will be a higher degree of scrutiny put onto it soon. So I probably made that much more complicated than I needed to, but
She moved out when she was served with the previous TPO.
She was arrested because she moved in with an existing arrest warrant because Padslit did not do a correct background check.
So she had an outstanding warrant.
Yes, Your Honor.
So, okay.
And she also had a TPO already put out against her by someone else.
Okay, so that's not, unless that person is a witness and it was party to something that you were involved with, that's not allowed to be considered by me.
Okay.
All right. So when was that she was arrested that you were aware of, if you are aware?
Please forgive me, Your Honor, I'm looking. Don't have it written on my calendar, but it was perhaps.
Was it after she moved in?
Yes, ma'am. Yes,
Was
Your
it
Honor.
before she was served with the temporary protection order that you're aware?
Yes, Your Honor.
Okay. All right. Okay. So, what happened that prompted you to file for an order of protection?
She attacked me in the hallway of the home when she was leaving the bathroom and I was going to it. I had already been avoiding her because of all of her threats. And I have evidence of videos of all of her threats, like yank my hair out, calling me horrible names, hate speech names. I have it all documented on my
Okay,
cell.
so hold on. So when she attacked you in the hallway, was that before or after you were arrested in this case?
That was before.
Okay. All right. How long had you been at the house before this happened?
Like 2.5 weeks, Your Honor.
And when you say she attacked you, exactly what did she do?
I was walking to the bathroom on the right side of the hallway, just trying to avoid her as I had been since she had already threatened me on several occasions, harassed me, banging on my door in the middle of the night. Like I said, I have videos to prove all that. So I was on the right side of the hallway, just trying to get to the bathroom. And she pushed me very hard. I landed on the floor. She then proceeded to beat me on my head and face. I have pictures of all the damage she did to my face, even had them pictures of them in healing stages, and called me horrible names. And all I did was defend myself. Her boyfriend is here, and he colluded with her in description to the officer, which is why I was, even while being treated in the ambulance, I was taken to jail because her
So this
boyfriend.
was the incident where you were arrested. Is what I'm
Correct.
talking about.
Yeah, and that was the severe beating, of which I have pictures I'd like to show you, Your Honor.
Okay, have you submitted those to the court?
I have not formally,
Okay, so your notice said that things need to be submitted to the court 24 hours ahead of time through that email.
I did not receive that.
The
You know
virtual
what?
And so this is again where the respondent, this is a great, great point where the respondent should have an attorney. If anybody is ever trying to get a TPO against you, get a goddamn attorney and shut up. Don't speak and get an attorney. That is your absolute thing to do. There's no attorneys on the screen except for the judge. The woman over here, the blonde, is actually a victim advocate. And so what's going to happen right now is the judge is actually going to cut the stream, thanks, and go ahead and allow this lady to collect her evidence, even though she didn't follow the rules by submitting it ahead of time. And again, as an attorney, you would just make a motion to continue. You wouldn't want to do that. You could just argue that. So again, these are the sort of little bits, but let's continue, see how the judge handles it, how my twin handles it. We do look alike.
court notice that has the TPO link on it.
Yeah, well, in fact, the sheriff said when they came and removed her, to always check your spam folder. And I was always checking my spam folder. I
So
did
this
not.
would be attached to the order that, or it would have come, let's see. Oh, it looks like Judge Cash issued this one.
Yeah, I showed Judge Cash.
No, I understand that this is different, new. So this is a whole separate hearing.
I mean, I have a traumatic brain injury. I'm on disability and I'm 52 years old. And all I was doing was defending myself by a younger female that was beating me horribly.
Okay, so I'm just telling you what the rules of the evidence are. So, um,
this is
have
when the
you
switch happens.
submitted any evidence to the court?
As of now, not up until this point, I will do so. I have the pictures on this phone right here.
Okay, so here's what we're gonna do. I'm gonna take a 10-minute recess
Okay.
to allow you time. Ms. Broom, could you give her the email
I'm doing it now.
to
Okay.
email us?
It'll be in your chat mail.
The virtual court notice that goes out along with the order has all the explanations of how to submit evidence ahead of time and the rules of court.
Okay, so when she sends me that email, I just attach all of my pictures to it.
She's not going to send it to your email. You're going to have to get the email from her and then send those pictures to the email, and you probably have to break it up if they're too big.
Okay, so CL Broom, oh, it just appeared.
Don't say it out loud.
Okay, I apologize.
So here, we're going to take, so I'm going to place Ms. Warmstadt and
then just like that, they cut, and then I have to find the next one, and I think that was this one.
We shot together.
No, it's not, but that's the cleavage one. Okay, that's the cleavage one, but that was not the one. This one. If anybody wants to get on me about how I don't organize or label the streams, you're more than welcome to volunteer to do it.
There we go. Good afternoon, everyone. We've been going nonstop since the calendar started this morning. I understand y'all were able to speak with the facilitator and unable to reach an agreement.
Nope, this is the one we already watched. Okay, so that means by default that it is after this. This one. We'll do the cleavage. Don't worry, we're getting there. Here we go. This is it. This is the good stuff.
All right, everybody could please come back on video and get to a place where you can be stationary. Reminder,
Can't tell if she's fast or not right now, actually.
any unauthorized recordings are prohibited at this time, and there have been no requests and no authorization. So any unauthorized recording, any willful violation of that can be subject to criminal contempt consequences. So at this point, we have everybody back. Miss Trance, were you able to submit any of your evidence?
Yes, Your Honor, I submitted several pictures of when it actually occurred.
Okay.
The damage and then as it was healing.
Okay, well, we can pull those up, Madam Clerk.
Warning,
All
they're
right,
not that
and
bad,
you can
though.
just tell me as we go through them. These appear to be more healing injuries.
Correct, Your Honor.
All right, and we can just go through them as she can.
Bob, that was one of the names I thought of for the channel.
That's again how it's healing.
All right, and around when were these taken?
Within 2-3 days after the incident.
Okay.
We're gonna
When
hear
they
it
start turning
again.
green, they're getting better. And that's even that's sooner after the incident.
All right.
Clock in for your shifts, guys. If you're just getting here, Georgia Peach, hit that like button. That was nothing, and that wasn't even me. That was the court. Okay, so this one's bad.
24 hours after the incident because I had gone to jail for battery when I was defending myself. I know you said that that's not what.
So I think we need to be thoughtful of that. If you, if if she gets taken away with those injuries on site, that tells me something. Something must have been feisty going on. And later on, we're gonna hear some opposite testimony. Let's just call it that. Opposite testimony. In fact, I believe, yeah, you'll see what I mean.
Case is about here, but
So what I said was, I did not say that. What I said was, anything you say in this hearing can be used against you in that case.
Okay.
Which is why I admonish you to think very carefully about any testimony you give today.
Thank you.
That's what it was. And you didn't need to tell me the whole spiel earlier when I was just inquiring if there was an arrest. But so having in mind that anything you say here can be used against you in your criminal case, I just need to make sure you understand that and are testifying knowing that.
Yes, Your Honor. Thank you.
Okay, so go ahead.
This was very soon after. 24 hours approximately.
All right.
That's another one where it's starting to heal.
I'm way more interested in what the fuck is going on in your calendar. Look at, she has TPO written on the back of her calendar. TPO case. Look at that. How would she already have the case number? That's weird. That's a lot of space to take up on the calendar. Also, that cat. That's a sexy looking cat. Fuck, there's so much going on.
Still healing.
Also, what is on the wall here? What do we got? What does that say? That's a certificate, but it's not in a frame. So,
And I don't need to see all the healing ones since I've seen so many. Are there any other pictures that are different from the ones that you've submitted from the healing and the day after?
Yes, there should be 3 others that are showing the very fresh injuries, the darkest of bruises.
All right, we'll see if those get pulled up.
That's the inside of my mouth. My lip was busted. Another close-up of the left side of my face within 24 hours, same as the other pictures of the most current bruising.
That's it, Judge. The other 2 is just the healing process.
Okay.
3.
All right. So what happened after that? If anything?
All I did was try to defend myself. And
Okay,
get
so but I'm saying after that incident, did anything happen between the 2 of you?
No, I ran away from her, got away from her as fast as I could and called the police.
Since that date, has anything happened?
Oh, no, Your Honor.
You said she made threats to you beforehand. What sort of threats are you talking about?
That she's gonna yank me by my straight hair, excuse my language, Your Honor, that I'm a fake ass white bitch. That I better stop recording her. You better stop recording me, and threats, horrible name calling. I could not use any of the amenities in the house and the pad split. She put
Wait, what do you mean you couldn't use any of the amenities in the pad split?
like we have common areas, the kitchen, the bathrooms, laundry, etc. And I felt unsafe to even leave my room to do anything. And the only reason she got to attack me in the hallway is because I was just going to the bathroom and I didn't know she was coming out, and she assaulted me in the hallway. It's the first chance she got.
So before the physical altercation happened, okay, so I'm gonna say something to the parties. Please try to keep your face civil, all right? Reactions and expressions in court don't make me believe anybody else more or less than the other, okay? So, and you're shaking your head while I'm saying that?
I agree with you.
Okay, I'm just making sure because you've been making some expressions that
I know, because I'm in shock. Like
I know this is very
legitimate.
I understand this is difficult for everyone. Every one of these cases is unique and very difficult for everyone involved. So just please try everyone to keep this as civil and respectful as possible through this process. Okay. All right. So ma'am, so you said that before the altercation, you said that you were recording her at some point?
Yeah, she was harassing me. I'm on disability. I have a brain injury. I take medication to sleep at night. service animal. She was banging and banging on my door in the middle of the night. I recorded her doing that. Because Pat Split, when you file a complaint on someone, they want all proof you can possibly get.
And let me be
Yeah.
clear, so for this, and just so all the parties are aware, what I'm gonna try to focus on, since we have lots of case, I wanna make sure you get your due.
Right, okay.
Roommate, there's roommate disputes, violation of house policies are not all family violence, and all family violence are not roommate disputes. So I'm gonna be trying to be laser focused on acts of violence or threats of violence in these. So tell me, when she's banging on your door and you start recording her, what's going on? Why is there banging on your door? Do you know?
She's banging on my door, accused me of putting pizza in front of her door. I'm vegan, I don't even eat pizza. And I told her that, she still would not stop.
Well, I'll just point out I live in a town full of vegans and there's lots of vegan pizza. But this is where we get down to the nitty-gritty of it.
Then she was kicking poisonous food. I had a service dog, kicking it underneath the door with boric acid on it, trying to poison my dog. And I told her to stop. I told her I was gonna call the police. And then I also have a recording of her, it was a video, of her saying, "You and that straight hair, I'm gonna yank you by your straight hair," which was a threat of violence. So I was scared to leave my room.
Okay.
And I have that video.
Have you submitted that?
I can now if you want me to.
Well, it's what you want to present to the court. So do you want to submit it to the court for the court's consideration?
I would love to do so. I have to, the phone that I'm using right now, I have two phones. I'm on disability, so I have a government phone and I have this phone, which is just a Wi-Fi app. So, I have to go into my, Google Photos and pull up that video. And, if you want to give me time to do that, I can do so, or do you feel that it's necessary or?
Okay, so just tell me this video, I might have, you might be able to do that in rebuttal if necessary. But you're saying you have a video of her yelling at you, "I'm gonna yank you by your straight hair."
Correct.
Was this around, when was this in proximity to when she moved in?
Maybe a week after at the most.
Plus, they already gave her extra time to get her
And
stuff
this
together.
was also, this was repeated all day long, all night long, bang, 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 threats, threats, threats. It never stopped. When she started, she never stopped. And then she finally got me in the hallway and attacked me.
What is your perception of why any of this animosity started?
Because she accused me of eating a piece of pizza and then taking pizza pieces and putting them down in front of her door. I don't eat pizza. I'm vegan. I told her this. I don't even eat pizza. And she would not hear it. She would not stop. And once that started, it never ended until the night that she attacked me and I was subsequently arrested.
Okay.
Pat Split did not do an accurate background check on her, and she had an active warrant when
So
she
you told me
moved in.
that that's not
I
relevant. That's not relevant to whether she's committed acts of family violence against you, unless the warrant involved you.
Okay. Sorry.
And they're not doing their duties. That's a landlord tenant thing. That's not
Okay.
a family violence thing. So were there any witnesses to any of these acts?
You know what? I stayed inside my room.
Yes, Pizza Slut Larry was a witness. He delivered the suspect pizza, and he will be called as a witness to determine if that pizza was vegan or not. I'm just kidding. Folks, if you're new here, this is Larry Beaver, one of our channel mascots, and and I always love getting photoshopped versions of Larry Beaver. This happens to be one we've named Pizza Slut Larry. If you can go ahead and subscribe if you're not already subscribed, we have a lot of fun here. I'll tell you that right now. If you are already subscribed, you should already know to hit that button. But yeah, do it. You know what button I'm talking about. You know. Also, um, what kind of pizza was it? Is my question right now. I want to. If we could call the pizza delivery guy, oh my God, wouldn't that be great? And it was Pizza Slut Larry, that'd be awesome.
The video I've told you about of where I'm recording her doing that, I did not see anybody else around. But there were witnesses to the fight. But one of them is no longer living here and the other one is not here at the moment.
Okay. How many people rent in this location?
8.
And around
That
what
sounds like a
time
nightmare.
of the day did this altercation take place?
Which one? The fight? It approximately it was about between 11:30 and 12:30 a.m. Saturday night, which would then I guess would become the 14th, Mother's Day.
Okay. And about how many people were at the house then?
I believe I believe 7, because there's one gentleman that works a late shift at a restaurant.
Okay.
His name's Pizza
Do you
Slut
know if
Larry.
those persons heard about the incident and spoke with the police?
No, the only 2 people that I'm aware of that spoke with the police, I was being treated in the ambulance, was her boyfriend David and another gentleman that lives here named Chris.
Okay.
And I've had problems with Chris since the day I moved in. I've been here 11 months, so we don't get along. So he was just really enjoying himself, colluding with Kylen and her boyfriend David to have me arrested. That's the only reason I was arrested.
Okay.
I was the only one treated at the scene.
Wow. Chris sounds pretty powerful. How is he able to convince the police, even though you were the only one treated at the scene, to arrest you? I thought you said she had active warrants. You're telling me they came and they arrested you even though she had active warrants? That's odd.
By the ambulance.
Okay. All right. Are there any witnesses or other evidence you want the court to consider?
I believe I've showed it all to you, unless, like you said, if for rebuttal purposes, I have the videos. But as of right now, no, Your Honor.
Okay. And has she had any contact with you?
No.
What's the last contact communication you had from her?
The day that the sheriffs came to remove her, I didn't even have any contact with her then. She tried to say things to me and they told her, don't do that.
I think we will find this second lady to be quite likable. I did anyways. Maybe you guys will tell me if I'm getting the different vibe than you, but you're going to understand once she starts talking, the faces and what's going on.
You're not allowed to speak to her because she was saying horrible things. But I personally—
What sort of things did she say?
She was calling me names and saying I did all, and the sheriff kept telling her that has nothing to do with it and watch your mouth. And that has nothing to do with it. We're here to serve this TPO. You need to leave immediately.
Okay.
She was calling me terrible, terrible things. As the other one that I told you, the hate speech.
Okay. All right. So Ms. Michenet, do you have any specific questions? You're going to have a chance to testify and tell me everything you want me to know, but do you have any specific questions you would like me to ask Ms.
Where's that
Trance
calendar
about
yet?
what she testified to?
No, I have no questions to her.
Okay. All right, so at this point, Miss
Is that?
Michenet,
I thought it was a picture of Kramer.
do you have, what would you like the court to know about what's been alleged?
Like everything was basically said backwards, like how she victimized herself, like it was actually done to me. So basically you can just like reverse everything.
Hold on, hold on. Yes, she just pulled an Uno reverse. Uno reverse. Uno reverse. she, I don't think that's like, I love it. It is not testimony we've always heard. Just reverse all that she just said. The judge is gonna make her go into it more, but her face, I just love it. Uno reverse.
Okay, so give me some details.
Like the threats at the door and the intimidation when trying to go do laundry. One of our roommates, Darius, had to like grab her and pull her into her room because she was just like standing there saying, "I'm going to put you in a wheelchair. You're going in a wheelchair."
Who did she say that to?
To me. And then she was acting like she was lurching forward. So he like ran down the hall and grabbed her. And then when he stepped out, she was calm again, like no longer trying to fight. And this was already after she had gotten out of jail. And she attacked me in the hallway, and I hardly spoke to her. I didn't even want to. I was nearly avoidant as I could be. I did not talk.
So tell me well, let me ask you this. Where are you living now?
I'm still living in Decatur, but about 5 miles away from there.
Do you have any intention to return to that pad split house?
No, absolutely not.
Okay.
I do have belongings there still, unless they've been taken up.
It was mentioned that your boyfriend lives there.
Yeah, it's not my boyfriend. I think that she's trying to be funny because her and James are actually together. So I think that's like a funny right there or something.
Okay. So tell me, when you moved in, what happened? Or when did things, tell me what you want me to know about how things got to where they are today.
All right, so like my food was getting stolen basically by she and James. And they were just upset by my asking about my food, that it turned out they were eating. James actually admitted it to me that they were. And I also heard them, like how she was talking about like her and her boyfriend are conspiring. Me and David, we were cool. We're like the closest in age in the past split, and we were roommates. I rode to this grocery store with him to buy groceries. Yeah, I don't know. It was a cordial, like friendly, high relationship. Well, we went to play pool one time. So I guess like she gathered that that was my boyfriend. I never told her that. Yeah, I don't know. I don't know why she thinks he's my boyfriend.
Okay, what about the boric acid and the boric acid and the pizza at the door?
So the place has roaches, and David had sprinkled some kind of insect powder.
All right, what about pizza at the door?
Yeah, she left pizza and like food sediment at my door, and I wouldn't have known it was her for sure unless I didn't hear her talking about it in her bedroom. I could hear her from the bathroom. I could hear she and James talking about it. They were looking for ways to upset me because, like I told you, I was avoidant.
So what happened on the night she was arrested?
She bit me. My finger actually, if you'd like to look, I posted pictures and it's still healing. A whole bite, like an animal.
It's
not nail polish, it's blood under my nail.
And then you have is the mark on your finger, is that from that as well, or that's different?
Yeah, it's a bite from her. It was bleeding and deep. I had to get it cleaned and everything.
Okay. So what
And I have
happened?
a scratch on my face from her. I didn't even know she scratched my face because I was busy trying to stop a fight from happening. So I didn't even know I had gotten hurt on my face. I didn't even feel that. She kicked at my stomach, ripped my sweater. I managed to have her sitting down, and she was upset that she was sitting down and no longer able to hurt me, I guess. And then she bit me. And I was the one who called the cops. James came down the hallway, got her off. If anything happened to her mouth, it was me prying my hands out of her mouth like I do with dogs.
So when you say James came and got her off, what do you mean by that?
She was holding onto my legs like in a leg lock to keep me from getting away. And when she saw that I was going to be able to get away out of her grasp, she grabbed my hand and bit me. And like was going for blood.
Okay.
She went into an ambulance faking like she was in there for a few minutes, then got taken into a cop car in cuffs. She wasn't hurt because right before the cops came, she was trying to prolong the situation. She was trying to prolong the fight. Once we got separated, she was still trying to fight me. And I was the one who let her know the police were coming.
Listen, it I personally believe the respondent. I got crazy vibes and also scheming vibes from the petitioner. A lot of what she said was, if you think about it now, very calculated. Uh Again, why you get a lawyer when you are being accused or being hit with a protective order. Okay. Her lawyer, oh my God. Can you imagine the police report, the pictures of the wound, her wounds? James, who's in the room with the petitioner right now, we see her talking to him and looking over at him. So we know, again, again, if the story was as what the petitioner says, why doesn't she have the witnesses available to say that? I can know why this lady didn't, because she's not allowed at that place and she wouldn't go back there, and she only lived there for 2 weeks. So she probably didn't have it's just get out of there, in my opinion, for her. I think, and also here's the thing. The lady that was pulling faces, I do believe she pulls faces all the time. I'm very similar. I pull faces all the time. I get in trouble for it. It's why I personally like to wear a mask, because I get in literally way less trouble because I'm very expressive with my face. And I think that she is basically um, surprised at all of this. She really, I don't think, was prepared for this, probably didn't take it seriously as she should, and like I said, hire a lawyer. It's the best thing you can do.
Okay.
Oh, so what I want in the chats now, in the chat, ladies and gentlemen, we are going to do a vote now before we get any eyes from Judge Davis. Do we think that this will be put in place for 12 months? 1 for yes, 2 for no, 3 for I don't know / I don't care. 1 for yes, 2 for no, 3 for I don't know, I don't care. Let us see. Another one, Mayor? God, these people need to right. I'm seeing 2s. I'm seeing a 1 from R. Fulmer. A 1 from Vicky. 3 from Sasheen. No worries. Michael Ferber doesn't care either. The big D from Valentino. Denied, I'm thinking that means. Lawrence Browning. Gamble all casual cannibalism. First of all, also vegan. That's not very nice of her to bite another living creature. Maybe she's like, this is my only chance. Holly, I think you've hit it right on the like on the, you know what I'm trying to say. There's a few things that need to be in place for a temporary protective order to be put in place. And one of those is a finding of family violence has occurred in the past and is likely to occur again in the future.
All right. What about after that? Did anything happen after that?
Yeah, actually, she still came into the house threatening me. She came back threatening me, making threats just like at my door. And the threats were like, I'm going to put you in a wheelchair. She said something about a rape one day, but then like walked off and sauntered off down the hallway. So I don't know what that was about. Just saying weird things. You're going to jail. So she was gonna like find a way to somehow get me in jail. She was saying she was gonna say I was trying to hurt her dog. Like she was like literally like taunting me and like saying the lies that she was going to say about me. She said that I'm gonna tell the courts that you took dog hair and tried to put it in my coffee, like just weird things that I would never even do.
Okay. All right. Is there anything else?
Definitely racial slurs. She was talking about my hair, calling my hair nappy, calling me a black bitch.
All right. Okay. Anything else you want me to know, or do you have any witnesses or evidence?
No, I don't. I do not now.
Okay.
I do have videos, but I was unable to post them, and I don't think like they're that relevant. Like I've said what I needed to.
All right.
Like I have like videos of her at my door threatening me, and like as I already said, like if you actually wanted to see her doing it.
Around when would these have been from?
These would have been from May 17th and onward.
Okay. All right. I've heard enough from the parties. These are very difficult cases when it's these kind of rooming houses. They fall under family violence only because the parties are residing together, but often there's landlord-tenant, co-tenant disputes that are woven in between them. One of the things I have to be able to determine is if there were acts of family violence, who was the predominant aggressor? And I have to find that by preponderance of the evidence. And then I have to be able to find that there's a reasonable likelihood of future acts of family violence by the predominant aggressor. The respondent no longer lives at the location, which even if I were to find there were acts of family violence, apparently y'all were in the same place for a few weeks. There's no reasonable likelihood of future acts of family violence. But honestly, I can't, with the evidence that was presented to me from both sides, determine who the predominant aggressor was at this time. So I'm unable to extend the order for 12 months at this time. The parties are free to take up any issues they have with their landlord companies or follow the criminal process as appropriate. And obviously call 911 if there is a crime. But at this point, there is not sufficient evidence for me to issue or extend this order. And so thank you both. You are excused.
Just like that, it was the big D denied in the chat. What do you think about that? Do you think that that was the right move on the judge? What do you think? We, yes, cleavage. Thank you, Jerry. Fuck. Thank you guys. Like, I needed that. I was like, what the fuck am I going to show next? I probably already said I was going to show something, but I don't remember what I said. So, thank you, Jerry, for reminding me of the cleavage. Ladies and gentlemen, give me 1 second. Let me hide my screen. This is what the scammers do. Scam artists. Oh no, it's meant to be like that, lady. It's okay. Hold on. Did we see this cleavage the first time or the second time? The second time, I think, when we went back. So it would have been the cleave.
Reach out together.
Sometimes we go.
Yeah.
Reach out
Okay, got
together.
it. Yes. Oh, that was first try, baby. Mm-hmm. That's like when you open a book to a page. Oh, I love it. So good. Good
Are you
night,
ready for the
Hyper Nikki.
parties?
Good night to everybody
Yes.
who's new and you're not staying. If you are staying, don't worry about it. Hang out, hit that like button, have a little fun with us.
If ever come, please start their video. Miss Williams. Miss Williams, if you can hear me, can you please start your video? Miss Williams, if you're driving, I need you to pull over.
Okay, let's place everybody back in the waiting room again.
Oh yeah, you do. I love Kipoga.
Do you want me to see if 18 is done driving?
Sure.
No, Richard, I see you. Sorry. Richard's here. I hope you're doing well. I hear that you're locked out of your PC.
Are you pulled over, Miss Johnson? You're muted.
Basically, I didn't full screen this until I was sure they're going to keep it because they cut this stream like
Yes,
blood.
okay, you're put over. Let me bring in a respondent. Are you in a place to stay put over?
Yeah, unless I need to, I'm like 2 minutes from the house, so.
Okay, well,
stay
we'll
here.
just wait. If you gotta drive, you can't, it's illegal to be on the phone and driving at the same time.
Yeah, I'm pulled over right now, so, but if you
Okay.
want me to go home in like 2 minutes, I can make it home.
No, that's fine. As long as you're put over, I'll bring in a responding judge.
All right, let me get back to this. A reminder that any unauthorized recording is not allowed and can subject one to criminal contempt consequences for any willful violation of that order. Also, as I said in the initial, I understand that virtual is more convenient, but there is no driving while court's in the proceeding. And as your notices said, you need to be prepared to possibly be in court the whole day, which sometimes we go all the way until 7 or 8 at night. So with that being said, I understand no one is driving at this point. So we will proceed with our hearing. This is position 18 on the calendar. Looking at it maybe point. So we will proceed with our hearing.
So apparently
this
I
is
didn't
position 18
make it
on
screen.
the
I'll fix it.
calendar. This is 23 PO 4707 Jerica Johnson versus Dalen Showalter. It is a stalking petition filed on May 12th of 2023. An ex parte order was issued on May 17th of 2023, and service was perfected by law enforcement upon the respondent on May 31st of 2023. I understand both of you met with the facilitator and were unable to reach an agreement. I do appreciate your efforts to do so, and we will go through the hearing and start it in just a minute. One thing for both parties to be aware, I will swear both of you in. The petitioner goes first because it is her burden under the law to prove by preponderance of the evidence that acts of stalking have been committed, and there's a reasonable likelihood of acts of stalking to be committed in the future. Stalking is the highest of all the protected orders legal burden. There are several things I have to legally be able to find stalking. A single crime does not constitute stalking. There has to be a course of conduct over a period of time, separate instances. So that's something I'll be looking at and maybe asking questions about if I am asking questions. The other thing I need to remind the parties, if there are any criminal charges, which I believe, Mr. Showalter, you may have been arrested for something related to some of the allegations. Is that correct?
Yes, ma'am.
Okay, so you need to understand that anything you say can be used against you in any future court proceedings, including your criminal case.
First of all, that was 1.5 speed. I was trying to catch up. I was like again, you miss this stuff, it's done.
Detrimental in your criminal case. So if you had a lawyer, I tell.
So here's the thing. Basically, I have to balance. I'm like, okay, I know I'm not that far behind, but I don't want to miss anything. But 2x, it means I will have to change the speed. 1.5, we should be able to get through it. These are the decisions I have to make all day as a minor in the courts, okay?
You to consult with a lawyer. You need to think very carefully about that before you choose to testify, if you choose to testify, okay?
Understood.
All right.
Oh, fuck, now I went full screen?
At this point, both of you will please raise your right hands. Do you solemnly swear?
I'm sorry, Judge,
testimony you're
please.
about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury? Ms. Johnson?
Yes, I do.
And Mr. Showalter?
Yes, ma'am.
All right, thank you. So what we're going to do is the petitioner will go first. She will present any testimony or evidence that she wishes to. And then the respondent, you may ask questions. If you want me to ask specific questions, you won't be asking them directly, but you will ask them to me, and I will ask her those questions. If there's anything you would specifically factually like me to ask her about as to what she's testified to. You also will have a chance to testify completely. You don't have to ask any questions and just testify and let the court know what you want the court to know if you choose to do that as well. But you will have an opportunity to be fully heard if you wish to. Once the petitioner is done, the respondent will have a chance to testify if he wishes and present any evidence if he has any. And then the petitioner will be able to ask me questions to ask you factually if there are any that she wishes to ask. Once I've heard all the evidence, I will apply the law to the facts that have been presented and make a determination as to whether an order will be extended in this case. All right?
Understood.
So,
Everyone's saying 1.5 is the best thing. It is, and here's the funniest part. What is very unusual for me when I'm streaming and live is that I only have one case going. Very, very regularly, I'll have 3 cases playing at one time while I'm listening and doing stuff. Like, seriously, it's normal for me, and I can like pick out the different cases for some reason, and I just laugh. But anyways, yes. So it's always very quiet when I'm streaming because I'm just like, yes, this is the one case.
I have the petition before me. Ma'am, a minute. Okay. So how do you know Mr. Showalter?
I don't know him. I only seen him the first day he came to my house on my Ring doorbell, asking if I put trash in his yard. And I was like, I don't even know you. I don't know where you stay. Why would I put trash in your yard? And he just went ballistic on my Ring doorbell, started threatening me. So I don't know him. I just
So how many interactions? So how many interactions have you had with him?
I had one interaction with him, and then he had another interaction with I didn't have an interaction with him. Just on the Ring doorbell, we were talking. That's the interaction I had with him. And then he had an interaction with my children, and that was in person.
All right. Were you present for that interaction?
I was not.
Okay. Are they here to testify about that?
No, I can call them on the phone and get them connected as well.
Well, the problem is if you weren't present and you have not filed on their behalf, it would have to be an act towards you.
Mm-hmm. I thought I put all 3 of us on that.
That's not how, so they might be protected parties. So anyway, I can't advise. You can talk with the Women's Resource Center about it. An adult gets a stalking order. for acts committed against them.
Mm-hmm.
The children might be included as members of their immediate family, but the acts of stalking have to be acts of stalking against you.
Mm-hmm.
So you're saying there's been one incident where he is threatened, where you had an incident with him where he came to the door?
Yes.
Okay. The incident with the children, you were not there?
No, I was not there.
Okay. And had they ever had an incident with him before that incident?
No, we never met him before. He just
Okay.
showed up at my house.
So he was arrested for that incident. And is there a bond condition ordering him to have no contact with your two children, or at least one of the children in that case?
Yes.
Okay, so that's pending. So there is that in place already in that criminal case. And is that the child that resides with you?
Yes.
Okay. All right. All right. So what were the threats that were made? And well, if you didn't hear them, right?
Right.
All right. Well, and it's just those two incidents that have occurred between y'all?
Yes.
Okay. So under the law, there has to be generally more than two incidents. And it has to be to one person. A course of conduct, sir, I need you to turn, thank you. A course of conduct over a period of time with no legitimate purpose for the purpose of harassing and intimidating someone. So basically what you've told me and alleged in your petition is not a sufficient grounds for me to issue a stalking protective order against him for you at this time. Okay. Like I said, someone can commit a crime, but it wouldn't, one crime and even two separate crimes would not necessarily constitute stalking under the definition of stalking. So that is what I am legally bound by. So I am not going to be able to issue a stalking order or extend your order for 12 months at this time. So I don't need to hear from the respondent based on the information alleged to me. That bond order is still in place for him to have no contact with your minor daughter who lives at your residence. And so he should not be coming there anyway. And sir, I would encourage you to abide by that and keep in touch with any attorney and make sure that obviously she's made it known that she doesn't want any contact with you. If there are future incidents, she may come back and refile, and there could be grounds for a stalking petition. So I would encourage the parties to, I would encourage you just to be in touch with your attorney on your criminal case and follow any bond conditions. And ma'am, if there are any future issues, obviously, if there's an emergency, you should call the police. And if there are any future incidents, you may reach out to the Women's Resource Center for assistance in refiling if you wish or need to. Okay.
Okay. And am I following the correct protective order? Because they told me not to, that it would have to be the stalking one, that I couldn't do.
There are no other orders for you unless you have a familial relationship. So it's the right one, but there has to be more incidents for it.
Right, because I don't know him and he just came to my house.
I understand. The legal definition is not always, the legal definition does not always line up with what some people feel like stalking. But I have to follow.
Yeah, Judge, I think we've uncovered a bit of a shit loophole here. And we've heard this before. There are different levels of protection orders issued in Georgia. They are based upon statutes, and there are certain criteria that need to be met. Again, why you get a lawyer. As a petitioner in this case, she should have had a lawyer. Again, where's the DeKalb pro bono guy who helps out like the weird witch lady or whatever that one was we watched? And this she's got some rando coming to her house. Like, this is serious. This to me is like, why are you turning this shit loose right now? This is not a waste of your time. The last case, waste of your time. This case, could you give it more than, let's see, 11 minutes? And here's the problem, right? She's like, oh, well, I'm bound by this, that, the other. Yeah, I know you are, but I've seen how you're bound by certain things in many ways, and y'all find little loopholes around it. The problem is you're the only one in there right now, and you don't care to find it. I think you're pissed off about her chest, to be honest.
The law, and based on what I've heard, I cannot issue one in this case at this time. Okay.
Correct.
All right. Thank you all. You're excused and
I hope to God that nothing bad happens, but that is an emboldening thing to somebody that could be very dangerous. You think she tried to find a way? I don't think so. She could have taken some testimony. She didn't even swear them in. Did she? Did I miss that? I don't think she swore them in. Okay. What was next? There was the cleave, and that's why, wasn't a great win there. Okay, I'm trying to think. I had some great traffic court today, guys. Really good stuff here. Really good stuff.
District
These
Court
are
infraction calendar. On June 8th, 2023, starting at 1:30, we have several matters, and I'll begin calling the names. But before I do that, I just want to let everybody know that on the traffic infraction calendar, there are several options that the parties have, and most of you have selected a contested option on your ticket. That means you're asking the court
what are we asking the court, Judge? Come on, tell us. Also, guys, this is in Washington, Washington State. And we're coming back up, baby. This is going to be good.
and make a finding. And that finding will be by what they call a preponderance of evidence, which is more.
Okay, the issue I have, guys, is flipping from court to court, state to state. I actually can't always tell what speed we're going at. At first, I was like, oh, he's at 2x, but now I'm a little confused. I'm going to play it at 1x for how I recorded it, and you guys got to tell me where we're at. Okay. I don't trust my own self.
And make a finding. And that finding will be by what they call a preponderance of evidence, which is more likely than not for the winning party. There are a couple other options. One is mitigating the ticket. Mitigation takes a position that you committed the infraction, but you're asking the court to lower the fines, and there's a reason why a fine should be lowered. And I'll certainly consider that if there's a good reason. There's one other option that may not have been listed on your ticket, and that is asking the court to grant you a deferral. If you have not received a deferral to any infractions within the last 7 years, you may qualify. There are a couple of conditions, though. CDL cannot get a deferral, and certain tickets, certain infractions like the school zone ticket, may not qualify for that. So that's another option. When you get a deferral, you have to pay an administrative fee of $150 per infraction. And if you do not get another ticket within the next 6 months, then this ticket gets dismissed. So that's another option you have. So starting with that on Zoom, let's see, I'll start from the top of the calendar, and that is Tricia Ann Carpenter. Docket item number 1, cause ending 979. Is Ms. Carpenter on Zoom?
He's a slow talker.
Those folks who do not respond.
And this is why I said 1.5 was weird, because I have a very strict rule. I either go 2 or regular speed, unless I'm not planning on changing the speed later, because that's the only way I keep track, because I actually personally can't. I can hear it fast. I'm a fast talker myself. So I think he's a slow talker. And yeah. Oh yeah, there's arguments. That's why Washington State are slow talkers. So that's what we're at.
I will come back to them as long as they appear before the court is completed. Next case will be Ruth Dorning, number 2, that is cause number 3A0165884. Is Ms. Dorning present on Zoom? Oh, come on up, please.
He is totally slanted.
So, Ms. Dorning, you have a ticket with 2 counts, and that is speed too fast for conditions and having no proof of insurance. And then you were cited for that on March 5th.
Yes,
2020.
I had a blowout, took out my steering and.
You can have a seat if you want.
I remember that day.
Okay. So how do you want to proceed?
I remember that day. Oh my God. I don't recall this part, you guys, but that is a big way to start the case. Yes, Your Honor. I remember the day like it was yesterday.
See today.
Well, first of all, I tell the police officer I did have insurance. I made her well cleared.
That you can down.
I clicked the wrong button, but police offer? Where are we at? There, I guess.
And then make a finding, and that finding will be what they.
Anna fucked it up that bad.
Which is admissible under the law. There are per infraction. Oh, come on up, please.
There we go. Sorry. I'm going to stop clicking things.
So, Miss Dorning, you had a ticket with 2 counts, and that is speed too fast for conditions and having no proof of insurance. And then you were cited for that on March 5th.
Yes, I had a blowout, took out my steering and.
You can have a seat if you want.
I remember that day.
Okay. So how do you want to proceed today?
Well, first of all, I tell the police officer I did have insurance. I made her well clear that I had my insurance, and she put down that I didn't.
Oh, okay, so you did have insurance?
Yes, I did.
Okay. Do you have a copy or?
I have it on my phone. That's
Okay.
all I have it on.
So if you pull that on and then show me so I can just verify that and then that take care of the insurance part. So in cases when you have had the insurance on the day off, but were unable to produce it,
She would give me the chance to produce it.
That sounds weird.
Okay, I see that your insurance was active from November through May 6th of this year, so that's within the period when you were cited.
May 5th was the
Our
day
Fulmer,
that
I believe the printer to phone ratio is probably 150 to 1. 150 people will have a phone to every one person that has access to a printer that has ink that will work, that they know how to use.
May 5th was, March 5th was the day.
No, March 5th. Yeah, I think so. Yeah,
March 5th was the day.
And I imagine it's gotten even worse since people started working from home more, because those people that had access to printers were usually people that were working and printing stuff on their boss's dime.
5th was when it was valid through. So you had insurance on that. So that portion will be found not committed. There's a $25 administrative fee because once the ticket is cited and you ask for a court hearing, that's an automatic charge. That's an administrative fee. So you will have 30 days to pay that part. Now, how about your too fast for conditions?
What happened was I was to go to speed limit. I told her I was doing the speed limit. I had a blowout. My blowout took out my steering. I lost complete control of my vehicle. And then I hit black ice and then it took off into the woods.
What?
And then
You
she said,
Oh, we have to go back for that because somehow something took off into the woods. This is but the insurance has been dismissed. Let's be clear. She got two tickets. Failure to produce insurance documentation, which she has just now had dismissed, and driving too fast for the conditions, which is a very, very specific charge that you have a hard time fighting because it doesn't require you to be speeding. If you get in an accident, you can be charged with that because it is your responsibility to be aware and preventatively drive for the conditions, and saying, oh, it was rainy, it was dark, it was black ice is not a defense. That still means you were driving too fast for those conditions and unable to properly maintain your vehicle.
For going too fast for road conditions.
Okay. All right. So I actually, I will not consider this as a contested any longer.
My vehicle.
That's an automatic.
I forgot to go back.
Yeah, March 5th was the day, and May 5th was when it was valid through. So you had insurance on that. So that portion will be found not committed. There's a $25 administrative fee because once a ticket is cited and you ask for a court hearing, that's an automatic charge. That's an administrative fee. So you will have 30 days to pay that part. Now, how about your too fast for conditions?
What happened was I was to go the speed limit. I told her I was doing the speed limit. I had a blowout. My blowout took out my steering. I lost complete control of my vehicle. And then I hit black ice and then it took off into the woods. And then she cited me for going too fast for road conditions.
Okay. All right. So I actually, I will not consider this as a contested any longer because I'll just review what I have in my file. What I have in my file is a report that the officer arrived after the accident.
Yes.
And then made some assumptions. And I am not going to find this ticket committed because the officer did not actually witness this. There are some conclusory statements.
Guys, I'm just letting you know, Big D, Dismissal Dan, has some competition. Today, you are going to be throwing Big D's in the chat for dismissed, and this guy might do it more than him. I shit you not. Although these are traffic, which makes way more sense. Big D is in bond court, but seriously.
Regarding what could have happened, and I do not believe that's sufficient for finding of a committed. So your count one, too fast for conditions, also dismissed, and your insurance ticket is also not committed, but you have $25 to pay for a court costs for administrative fee.
I'll
or not.
pay that.
Okay, you can go to the window at the clerk's office and make arrangements.
Okay.
All right, you have a good
I
day.
can go now.
You're free to go.
Oh, and then I wanted this. Okay, thank you.
All right, first dismiss.
Amanda Hare. Is Amanda Hare present? I see Amanda's iPhone. Okay, we'll get back to that. Bruce McDowell. Calling for Bruce Scott McDowell, 3A0201994. Is Mr. McDowell present? Okay, we'll get back to that. Jacob Colby Mulink. Come on up, please. So, Mr. Mulink, you have asked for a show cause hearing. What that means is that you must have missed your court date previously and ticket was found committed.
Our full, or sorry, insert funny name. You're correct, but the reason there's an administrative penalty on that is to deter people from never carrying their insurance paperwork with them, and I believe that's probably because they want people to carry it with them. So instead, if it was never a problem to not have your insurance paperwork with you and you could always, there was no repercussions, then there could be, I can see how that could trickle and spread, unfortunately, to people. And that just makes people's jobs harder. So I understand why you're saying, oh, you shouldn't have to pay to go to court or have a dismissed ticket. That's an administrative penalty for requiring the people in the office to phone and verify the insurance is actually valid on the dates, because you can easily make fake paperwork. So somebody has to actually administratively verify it.
When you had set it up for a mitigation, this was a speed ticket, and then you're asking that that be recalled and we readdress your ticket. Is that correct?
That is correct. I lost my mail key, and then when I finally was able to get it back, and I opened it up, and like, holy moly, I missed my court date. So
Okay, I'm happy to recall that and readdress this matter. You had initially asked for a mitigation. Um, is that your position still?
I would like to apply for a deferral.
Okay.
I committed the speeding. I was just trying not to
Okay.
have my
Yeah,
insurance.
deferral will cost you $150, and it may be more than the face value of the ticket. But if you don't have any tickets in the next 6 months, this gets completely dismissed. So we will provide you a copy of the form, a deferral petition. You can file that with the at the window, and you have, I believe, 60 or so days. They'll let you know how soon you have to pay that $150.
Okay.
And then just have no future tickets for next 6 months, and this gets dismissed.
Perfect.
All right, you can come pick up the paper.
Thank you.
You have asked for.
Okay, here's the best part. This is the part that I was this is the one, okay? So, first of all, Mr. Robison on screen right now is afflicted with a similar facial expression life as the lady from the other case. And I literally thought he was connected to Amanda's case coming up, because he is so interested and was like so animated while listening to her. But then his case comes up after hers. So pay quite a good attention to Mr. Robison here as Amanda really gets upset.
Can you hear
I'm
me?
sorry, I'm not sure who is speaking.
Amanda here.
Also, before Amanda gets in here, what the fuck is a Nokia 1.4? I'm being serious. What is that?
Amanda Hare, okay. Okay, Ms. Hare, you have asked for a contested hearing on your case number 2A070967 and you had 3 infractions: speeding, following too close, and improper lane change. How would you like to proceed?
I just kind of wanted to say my side. I definitely feel as though I did not act as I should have, but I felt in a way that I was kind of matching the officer's energy that he was giving me. He didn't really mention in his statement that he instantly, when he pulled me over, told me I was a horrible driver, and then continued to accuse me of multiple items in my vehicle being marijuana, which they were not.
All right, so I still have to understand your position as to, so how the contested hearing works is I put you under oath, then I hear from you your side of the facts, and then I go into court files and I review what has been filed, and if there's enough evidence which is admissible under the law, then I compare both sides, and then depending on who has more likely than not argument for finding of a committed or not, then I will give my ruling accordingly after that. So, but again, you have a deferral option and mitigation options as well. What would you like me to do? Would you like me to put you under oath and then hear the facts, or or have you present your evidence if you have any witnesses or any other evidence? Ms. Hare, we thought we lost you. Okay, you're back. So did you hear what I just said?
Yeah, you were saying what you wanted to hear my side, right? For a
If
minute,
you're
you were saying that you
contesting,
have
if you're
their side
contesting,
and
so
then
if you choose to contest and then be put under oath to testify, then that's the only option we can proceed with.
okay.
So are you contesting it?
I mean, I don't necessarily know. I wanted to kind of just say my side and kind of go from there.
Okay. So, but you're not sure which option you're selecting at this point. You just want to tell your side of the story as a preliminary matter?
Right. Just to kind of figure it out because I felt like I didn't necessarily get to explain to the officer why my driving may have been poor because of his aggressiveness. So I felt like at the time, I felt like he was just trying to charge me with whatever he could.
Right, Mikey? I don't know if the judge is okay.
I
He is
feel
talking
India
slow.
that I was unsure, so maybe probably or whatever. I felt like I was very aware of my surroundings.
Okay. Let me ask you this. Have you had a chance to review the court filings by the officer in this case in terms of evidence?
Her
It looks
internet
like
sucks
we
worse than mine.
have temporarily lost Ms. Hare. Until she comes back, we can, she's trying to log in. Is Deanna Piles here?
Yes.
Okay, give us just a second. You're showing as Nokia 14. That's you, Miss Piles?
Oh, yes.
Okay, if you want, you can change your name on the screen if you can, but if not, I know that you're there. So, Miss Hare, we're back to you. Have you had a chance to review the evidence that was filed in this case?
Yes, I have.
Okay, so so tell me, what would you like to do? Would you like me to review that evidence and put you under oath and then go to the contested hearing and make a finding?
Yeah, we can do that.
Okay. Okay, raise your right hand, please. Do you swear or affirm that your testimony today will be true and complete to the best of your knowledge?
Yes.
Okay, go ahead. Tell me what you want me to hear.
Okay, so I was driving in an unfamiliar area. I was headed to work. It was early in the morning. I was not scared than the last time I had been on them. I felt as though maybe, yes, and maybe was sort of on lanes is what she was saying is why he started following me is because maybe I wasn't, but I was just I felt like I was aware of my surroundings at all times. So even if I had made a few incorrect changes when I'm driving, if I just was unsure of where I was going and I didn't have my phone to have GPS, so I wasn't able to know exactly. I was just kind of going off of the roads. But whenever he pulled me over, he was instantly aggressive, told me I was a horrible driver, and I felt like he was attacking my character. When I was grabbing for my registration, out of my glove box, he accused me of multiple items being marijuana, which they were not. And so I just felt like he was kind of attacking me. He never once said that he felt that I was under the influence or anything. So I wasn't sure why he was trying to accuse me for anything being marijuana in my vehicle. So I felt like I didn't really get to tell him that I was lost, wasn't really sure where I was going, and the vehicle that he said that I apparently cut off, that I was trying to get past that vehicle because his tires were spinning things up on my car. So I was trying to go around him, and I feel like the point that I was maybe speeding was whenever I was trying to pass him to get past his vehicle.
Okay, so I understand your position as to the following too close and lane changes. You're saying that those facts, the way you are presenting, are obviously different. You're saying that you're fully aware of your surroundings. What about the speeding?
The only time that I felt like I was speeding is whenever I just said that I was trying to get past the vehicle so that I could get ahead of him so that his vehicle wasn't spinning things on my car. But I wasn't full speeding the entire time he was following me. I sped up to pass a vehicle, which I thought was appropriate.
Okay, I'm reviewing Trooper Matthew Newman's affidavit that he has filed under the penalty of perjury, which means it is admissible for me to review. He says he certified that under penalty of perjury under the laws of the state of Washington. And then he is going into his narrative by saying that he has been commissioned officer since May 2015. He used a V3 DSR speed monitoring device, which was tested and displayed the speed of the vehicle consistent with his visual estimation. And that SMD radar, it's was in the vicinity of milepost 109, but he had
Right, but how was I?
Do you think he has to rub his eye like that to make it happen? With his hand up like that? What does he call that? The reverse eye fuck? Spelled IFUCK?
Following someone too closely if I was going faster than them?
I'm getting there. I'm still reviewing that. Says she nearly struck a vehicle which was traveling 60 miles per hour. As to the speed, he has laid down sufficient evidence. I do not find that you committed too fast for conditions. No, I'm sorry. Following a vehicle too closely or doing an improper lane change. He does say at one point that you made a right signal and then made it lane change into the left side, but that's still not sufficient for those two counts. I do think that there is sufficient basis for the speeding infraction, but I'm still working on that. So his radar docketed you at 83 miles per hour in the 60-mile zone. Do you have any evidence to rebut that?
Not particularly. Like I said, I didn't necessarily think I was going that fast, but I was just speeding up to try and get past the vehicle. So
I'm serious. David Robinson's faces are what's making this case for me. He is just, first of all, now I've realized it. I've watched. I did show some cleavage. I've got more cleavage. Don't worry. Didn't you see my my archives? No. But seriously, uh, I he's not. I realize now he's not upset. First I thought he was the officer she was talking about, but he was trying to warn her to not do what she's doing. It wasn't good cleavage anyways, and the judge was the cause of that being a short hearing.
Give me just 1 second. Okay, these are the only tickets that you have on your record and your.
Yes, and I'm 31, so him coming up to my vehicle telling me I'm a horrible driver before he has ever even looked at my record, I felt was a little aggressive.
It says your license is expired. Have you renewed
Yes,
your
just today,
license?
or yesterday, sorry.
Oh,
I'm
really?
doing it today. I was out of town for family stuff.
Well, otherwise, you have a pretty decent. I mean, you have no tickets at all, so it's more than decent traffic infraction record. In this case, I'm finding that you did not commit the infraction of following too close, and you did not commit the infraction of improper lane usage. I do find that you committed the traffic infraction. The total fine for the face value of the ticket was $499. $221 was for the speed. I understand you have contested this, but I will still give you the opportunity to tell me why should I reduce this fine and allow you to mitigate further beyond contested. This is a pretty hefty fine of $221. If there's a reason that is convincing, I can try to reduce it a little bit.
Like I said, I didn't honestly feel like I was speeding that fast. And unfortunately, if that's what he radarred me at, obviously I was. But at the same time, like I said, I was just trying to get past the vehicle. And I know he said that the other vehicles were going 60, but if I was speeding up that fast to just get past someone, I don't feel as though those vehicles were also going 60.
Okay. Your speeding ticket count will be found committed, and I'll reduce the fine to $150. You will have 30 days to pay that, and the other two counts are dismissed. If you have any questions, let me know. Otherwise, you can contact Thurston County District Court and make arrangements.
Okay, thank you so much. I really appreciate it.
Thank you. Have a good day. All right, let's see. From 1:30.
Okay. And you're going to understand why in a moment. David up here thinks he is king. And he sort of is.
Calendar, David Robinson. Mr. Robinson, I see you are there. Is Trooper Hausen on Zoom? Do we have Trooper Hausen on Zoom? I don't see him. And can you confirm that he was subpoenaed? I have my note that he was. Mr. Robinson, is that correct?
Yes, yeah, that's correct.
Mr. Robinson, you had a ticket citation from February 28th of this year, speeding 19 over the speed limit. And did you request a subpoena to Officer Robert Hausen?
I did, yes.
I do not see Trooper Hausen on Zoom platform or in court. And because you had requested that he be present to testify in this case, and he is not, so based on that, I will dismiss your ticket.
Great, thank you, Your Honor.
All right, you have a good day, sir.
You too, bye-bye.
Is Deborah Stevens present? Okay,
He doesn't
go
even
back,
have
going
to
back to
talk
Ms.
about it.
Files.
He doesn't even have to explain that he was busy or whatever that day, and he knew it. This is why he was smiling. He's like, "You dumbasses contesting it. Subpoena the cop and watch them not show up." And he's right, which is sort of sneaky.
Deanna Lee Piles, cause ending 332.
Your
Ms.
Honor,
Files,
Your
Ms.
Honor.
Files, you had asked for a show cause hearing. Is that correct?
It's been it's been a while, so I guess I did. I don't what I need to do.
Yeah, this is a ticket from December 2022, and your ticket is for having no insurance.
Okay, I thought it was for the suspended. I did not realize it was suspended when they- when I got pulled over.
Okay, go ahead.
Apparently, when I got pulled over and I thought I was cited for, a suspended license, which I didn't realize that my license was suspended. And then, no insurance, and I was using my sister's car, and I believe she had insurance, and I have, her card from that, so
You were
I
not
don't know
cited,
what.
you were not cited for suspended. He may have given you a warning or something about it. Let me take a look. Hmm.
Is she in a hotel with those curtains? Or just like a Sims house that doesn't have the roof on?
She was written an infraction for operating a motor vehicle without insurance and given a verbal warning for driving license suspended in the third degree. And you're saying you were driving your sister's car?
Uh-huh.
Okay, and then you believe that she had the insurance on December, whatever that date was, that is
Yes.
December 31, so last day of
Yes.
the last year.
Yes,
So
I
would
believe.
you, I can recall your case, and if you're asking me to reset this for a hearing so you can bring a proof, are you able to bring a proof of that insurance today?
Not, what time? I mean, when? I can't right now. I don't have it with me, no.
If you are, we are going to be here at least until 4 o'clock. If you want me to hold off on your case and have it recalled, if you have insurance proof available that you can show me on video.
Uh-huh. Um, she's working right now, so I guess I would
So
have
we can,
to
we can
schedule.
continue this few weeks.
Okay.
Okay. And you had initially asked for a mitigation, and is that your request still?
And
Oh,
I suppose. Oh, I would like the ticket lowered. I mean, I can't say that I was driving, so I was not aware
no,
of my.
we will reset this matter on a Thursday afternoon, either on 1:30 calendar or 2 o'clock in next 2 to 3 weeks. I'm going to find out what dates we may have available.
Okay.
What happened? I didn't do that.
We have room on 29th.
He's super accommodating. He is and so here's the thing. I started watching at the beginning. I caught those first cases and then I was like, I know that looked epic, Mikey, like as
No,
if somebody meant to do it, but I didn't.
should be bring proof. So
But I kept
1:30 or 2
going.
o'clock. We will reset your case to June 29th at 1:30. And it'll be a
Okay.
contested hearing, but if you have proof, that should resolve the case in your favor. You
Uh-huh.
you have to make sure that you have all of that paperwork provided to court in advance or at least on the day of. If you're able to come in person, you're welcome to do so, or you can also make the arrangements to appear on Zoom. But
Okay.
if the court has that paperwork in advance, that'll be greatly appreciated.
Okay, so I can just drop it by or whatever, then if I have before that date.
Yes.
Okay, okay, got it. Great, thank you very much, Your Honor. Mhm.
Also, where is Deborah?
Is
I'm
Bruce
sorry.
McDowell?
No, where's Deborah? Deborah. I'm sorry. I'm such a silly person. Seriously though, it's very shiny. Is that a fridge? I'm thinking it might be a fridge. At first I thought it was a gray metal. I couldn't really place it. I thought high school, like locker, but too shiny. So now I'm thinking refrigerator, odd color, either expensive or old, you know. Fridges are fall into those two categories when they're not normal colors.
Available? Bruce Scott McDowell, Trisha Ann Carpenter, Deborah Stevens.
Yes, Your Honor, sorry. I
Ms.
was,
Stevens.
It's
Good
Deborah.
afternoon, Mr. Stevens. You have asked for a show cause hearing on your case, which is cause number 2A0725788, and it is a improper lane usage ticket.
yes, it is.
And I am going to recall this matter, and based on your prior failure to appear, it may have gone in your record as a committed, but we can recall that and readdress this matter today.
Okay, thank you.
And how do you wish to proceed?
Contested. I didn't.
Have you had the opportunity to review the officer's narrative or any evidence that was filed in this case?
Unfortunately, Your Honor, I did not do that. I submitted some material of my own. I had a lengthy conversation.
Okay, so who amongst us would ever reply to legal paperwork without reading it? I'm being serious. That sounds really dumb. Why would you do that? What if you're talking about something totally different? What do you mean you didn't read it? Well, what did you send? I'm so confused. Like, that baffles me. I read everything. I read it again and again and again. I read every single thing I see that has words on it. That's why I like watching court, because I'm a nosy bitch. I love getting to see all the shit. I mean, seriously. Legal paperwork? One of my friends is like, oh, I got this legal paperwork. I'm like, real? You want me to help? You want me to look at it? Really? I can look at it? Fuck. Like, do you know how badly I've wanted to see one of the case files of CPS? Like, I want to see it. Seriously. So it just baffles me that you would literally reply to legal summons or legal paperwork without first reading them. Seriously, what if you admit/defend a different crime? What if you're like, oh, like seriously, that's funny to me.
With him at the time that he came. It was an accident that he came to after the fact. And I submitted, so I wasn't able to access. I feel a little stupid, but I couldn't find it on the website. So, but
Okay.
I'm sorry.
Let me see if I can open it up. There's a way for you to review that, and if you want, I can allow you more time and then come back to it by going to Thurston County District Court's website and the services and electronic records. You can view everything that is filed in this case.
yes. So, Your Honor, I did question him about why he was giving me a ticket, because I really didn't. I did everything by the book, and he said it was because I was because the impact was in.
Miss Stevens, let me stop you. I have opened up the file and I'm reviewing your exhibits that you have provided the court in this matter. And this is in fact a case which I can, without having a contested hearing, find not committed based on the lack of evidence.
And apparently I'm wrong. Fucking send in paperwork. Don't even worry about reading the shit that the cop sends. Nope. Totally wrong, Kitch. Look at that. Just prove me wrong, Judge. Seriously. Are you joking? So you're telling me there was no evidence in the paperwork that was sent to her? That's even more confusing.
This case.
Hi, Charles. I hope you're doing well today. I hope everybody's doing well. If you're still here tonight, you know how we go. You better clock in for your shift, though, Charles. Seriously, you're on grill tonight.
I see that there's a narrative that says that
And don't get on about, oh, I can't stand, I'm not able to. No, none of that moaning.
the officer arrived after the fact, and those are all conclusory statements. So I am finding this ticket is not committed.
Thank you very much, Your Honor.
Thank you. You have a good day.
Thank you.
Anybody else present from 1:30 calendar? Last call, Trisha and Carpenter.
That's awesome, Charles.
She's what?
Hi, Crystal. What's up? No worries, Mayor. It is getting late East Coast time, still early West Coast.
That was depending on.
Just dismissed everything, basically. I'm just not even gonna lie. I think.
Okay.
Let's go see what other gold nuggets I dug up today. What else did I dig up when I was mining in the mines of court? Oh, and people ask, do I listen to podcasts? No, I listen to court all day, all night, all the time, multiple ones at a time. It's not that I don't like podcasts or appreciate them. I just have ADD and I hyper focus, and this is what I'm hyper focused on probably for the next 5 years. Oh, med check, med check, med check. That means if you take meds, take them. Think about taking them. If you don't, go ahead and tell us what that's like in the chat.
All right. And it looks like you've used the deferment program previously.
Did I?
Yeah, the clerk's note indicates that you used it in 2018.
I
can look.
might have Judge. I might have Judge.
I'm gonna double check here just a second. 2018.
Nice
I might have
banging.
Judge. I don't remember. I might have.
Yeah, looks like you used it
Charles.
January 4th, 2018 on a speeding ticket out of is that Wood?
This guy looks high as fuck. Polly says, "This is the judge, Polly. This be the judge." This is also in Washington, folks, and this I think is also traffic. Again, I trust my previous kitchen instinct. I recorded it for a reason.
Woodland.
Woodland.
No, sorry, Wahkiakum County District Court.
Oh, that's in
Cathlamet.
Cathlamet. Yes, sir.
Okay.
I might have, sir. I might
Okay.
have.
Well, that's what your record shows. So that means you're not eligible for the program now. Be a couple more years and then you can do it again. Anyhow.
Yes, sir.
So we have a speeding ticket. Officer cited you for 5 over the speed limit.
Yes, sir.
And you want to contest the ticket?
Well, sir, I don't think I was going that fast, but because my car is a piece of crap, so it barely gets up to 65 miles an hour. And he said he caught me at 80 something, but I just don't see how, because car put, and I got to really push it to make it go that fast,
Oh, see? Previous kitchen is good. She catches great shit. My car is too bad to go that fast, Judge. Put. I want to hear him say it again.
But, because my car is a piece of crap, so it barely gets up to 65 miles an hour. And he said he caught me at 80 something, but I just don't see how, because car put, and I got to really push it to make it go that fast,
Were you coming downhill with a strong tailwind?
I think so, sir.
Okay.
You know, so, and I wasn't, and because, you know, I'm trying my best not to go, get no speeding tickets, sir, because I'm in truck driving school and I'm on disability, you know, so I'm trying to better myself. And I really can't afford to pay a ticket because I don't have the money. I'm on fixed income. But I'm trying so hard, Judge, to better myself, you know. I'm trying to get custody of my son and my daughter that's just in the system. So, you know, I just know, I don't think I was going to say it. That's all I'm saying. The officer might be right because I was going down a hill. And that's about it. That's about all I can say.
Oh my god, he was going down a hill. Oh my god, oh my god, oh my god. Oh my god, I don't think the judge was serious. Oh my god, oh my god, oh my god. He thinks he was serious. Oh Lord. Oh, oh my god.
Okay.
The judge is laughing.
Well, here's the deal. Okay. I have read the officer's affidavit. He does indicate that he clocked you at he says 88 miles per hour.
Yeah, that's what he told me.
Yeah. That you were in lane 3 of the three lanes.
Yes, sir.
Says that he did visually estimate your speed at over the speed limit.
Yes, sir. Like I said, sir, Judge, I was coming down a hill because it's over there by headquarter road.
Yep.
And it's a little steep as you're coming down right there.
Oh, I'm very familiar with that because I drive through there every day.
Yeah, I'm not saying I didn't do it, but you know, for me matching the gas to do it, I don't think so.
Yeah.
But if you know,
well, he's
already
reduced the ticket from 88 to 75.
I know, sir.
So I think we're gonna have to go with the 75 on this one. Okay.
Yes, sir.
Let's see. 3A.
Yeah, he was in the fast lane, right, Raven? Another one, Avs?
There is $114 fine that has to be paid. And it has to be paid within 60 days of today's date. If you can't
take that back,
make
Tupac. I was born in 1988.
$14, then you need to at least set up a payment plan, okay?
Yes, sir.
If you don't set up the payment plan, then Department of Licensing is notified that you're not paying your fine and they suspend your driving privileges.
Yes, sir.
Okay.
So I can go to can I go to the court of clerks in Callis County and pay it?
It would be paid at the district court clerk's office.
Yes, sir.
Okay.
Yes, sir. Yes, sir.
All right, sir. Any other questions?
No, sir. You pretty much summed it up for me, sir.
All right. You have a good day.
You too, Judge. Thank you.
All right.
Bye.
Okay. Next case I have is Jenny Wong.
Hey, Your Honor. Can you hear me?
I can. Good afternoon.
Afternoon.
Thank you for being patient with us today.
Thank you for your time.
Looks like, so you have a CDL?
Yeah, so I would not qualify for deferment.
Right. We can't, yeah. I don't know why they do that, but okay, so we have a seatbelt violation. Let me read the officer's report to you, okay?
Okay.
So that you have an idea of what they've got to say. Just a second.
This one actually turns out
Let's
to
see
be
if I can
very
make this
interesting.
a little bigger for me here. My eyes are getting tired.
It's after 4:20.
Nope, doesn't look like it. Okay, here we go. You ready?
Yeah.
All right, it says on March 13, 2023 at 8:53 hours, I was working enforcement on Interstate 5 in Kelso, Cowlitz County, Washington, was traveling north on the interstate. I was passing a blue 3 conventional day cab semi-tractor truck, bobtail, also traveling northbound, and I saw the driver of that particular commercial motor vehicle was not properly wearing her seatbelt, as the shoulder harness was routed across her left arm and routed across her left arm and across her rib cage and abdomen. This was made abundantly clear and easy to see because the driver was wearing a dark colored jacket and the seat belt was bright orange in color. Due to heavy traffic, I was not able to position my vehicle behind the truck to safely stop the driver. I proceeded down to the jump zone at milepost 37, ahead of the aforementioned commercial motor vehicle, and waited to confirm that the driver was not wearing her seatbelt correctly. The vehicle passed, and once again, I observed that the seatbelt was across the driver's left arm. I merged back onto northbound Interstate 5. I caught up with the aforementioned vehicle at milepost 38 and activated my emergency lights on my fully marked Washington State Patrol vehicle. The driver stopped her vehicle at milepost 39, and I exited my vehicle to make contact with the driver. When I made contact with the driver, I observed the driver was disengaging the factory installed seatbelt lock on the left side of the cab behind the driver's door. When I opened the door, she had completed the process of wearing the seatbelt correctly. I obtained the driver's Oregon commercial driver's license, which identified the driver as Jenny Wong. It's got your birth date. I verified the description, and picture of the license matched the appearance of Miss Wong. Notice of infraction was issued for the seatbelt violation. I explained the entire notice of infraction to.
Well, it's one thing to just pay the ticket, Polly, but in fact, a CDL is a commercial driver's license, and I believe there are some very strict rules and regulations about the type of tickets that you're allowed to receive while still maintaining that licensure. So it doesn't surprise me that she is contesting it, a commercial driver would be. Mayor, that's funny.
The defendant, Ms. Wong, was professional and courteous throughout the contact. That's pretty much it. So
Okay.
you go ahead and make your argument.
So I did have my seatbelt on at the time. I thought that I was properly fastened. I did reach over to grab documents for the officer. So, I don't know if that stretches out the belt or not. I, at the time, believed that I had my seatbelt properly fastened, and I didn't feel that I was putting myself at harm how it was fastened. Although I have since reviewed, documents on how you're supposed to properly fasten your seatbelt.
Okay. And
And go ahead and incriminate yourself further. This is another case where you should have either just subpoena the officer and hope he doesn't show up. That's your best bet. You just literally said, I didn't do it. Except now that I've looked at it, I probably did.
It can always be improved upon, the technique on how you're fastening your seatbelt.
Okay. So let me ask you this.
Okay.
Was your seatbelt properly fastened while you were driving the vehicle on Interstate 5?
I believe so.
Okay. Was it across your shoulder?
It was, so it kind of, it's back here. It was coming across like this. So the officer said that there was slack, so I don't know. I'm not 100%
He's not
sure the
he's not
position.
indicating in his statement that there was slack. And this is what I don't quite, he's not clear. And I'll read this part.
Oh no, Vicky, we're pretty sure it's after 4:20 over in Washington when I recorded this. And yeah.
To you again.
Okay.
Let's see. Okay. It says, I saw the driver of the motor vehicle was not properly wearing her seatbelt, as the shoulder harness was routed across her left arm and across her rib cage and abdomen. So I'm trying to figure that description out.
I'm really high and it's hard right
Because
now.
normally your seatbelt would come across here. Your left arm would be, unless for some reason you had your left arm across your abdomen.
I'm confused now.
I will just make this easy. We're going to find that it says not committed. His description is really not. He doesn't say that there was too much slack in the seatbelt. He does mention that toward the end of the declaration that you were disengaging the factory installed seatbelt lock, which would create slack in it. But he doesn't say that, there was a lot of slack. Oftentimes we see where you can take the seatbelt and bring it, 12 inches away from your body, that kind of a situation. That is a lot of slack, and it would not stop you from going through a windshield.
Okay.
But he's not real specific enough, I think, with regard to his description. So I will find this as not committed.
Thank you, Your Honor.
Please, in the future, wear your seatbelt the way that you're supposed to so that you don't go flying through the windshield.
I will.
Thank you.
Thank
You're
you.
all done. You can go ahead and log out. You have a great afternoon.
Okay. You as well. Thank you.
Okay.
Oh
bye.
yeah, Jim
Bye.
Halpert. Thank you.
Next case I
Congrats on 1 month.
have is Brenda Zacharias Lopez. And if you could please.
I think that was all that was interesting from him. I know I got something else that I wanted to show you guys. Where was it? Oh. One of my faves, you know it. Judge Webster from Texas.
This court is going to call cause number C242471. This is in the 317th District Court of Jefferson County.
All right, Judge, just before you get going on that, first of all, I'd like to first thank you for just how efficient your court Zooms are. You are on it always, and I just want to say thank you. I don't think enough people probably do, Judge Webster, because I personally know how fucking hard it is to keep things on a schedule and stuff, and you do a great job. That's what I first want to say. Secondly, I'll introduce Judge Webster to anybody who's new here and doesn't know Judge Webster from Texas. This is not the same Judge Webster, obviously, as the one in Kansas, but he is, I dare say, better. I'm not kidding. I'll take this Judge Webster over the Kansas one any day. And I would absolutely want to have dinner with this one more. I haven't watched this, full disclaimer, have absolutely no clue what we're going to see.
Texas, and it's in the interest of Matthew Martinez. Ms. Wiesenant, would you raise your right hand and tell me that your hand is in the air?
Yes, sir.
Ms. Wiesenant, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. You can put your hand down. Mr. Martinez, would you raise your right hand and tell me that your hand is in the air?
In the air.
Mr. Martinez, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You can put your hand down. Ms. Overstreet, your case has been called. My understanding is there's an agreed order on this case.
Yes, Your Honor.
All right, prove it up.
All righty. I'd like to first read the record.
Oh, I love that. I want to remember that. That's going to become one of my catchphrases. Prove it up. Prove it up. I love him so much. See, do you know why? Do you know how much I love him? This is an agreement, and I'm going to watch it. And if you're here, you're a court nerd, and you're going to watch it too.
The agreement into the record, and then I'll ask the parties. There was originally an acknowledgement of paternity in this case, and then in a prior case that was actually filed in Jefferson County, there was DNA that did find that the probability of paternity was 99.9. So I probably need to put one or the other of those into evidence first.
You've got an agreement. It doesn't matter.
Okay. The agreement is that the parties will be joint managing conservators of the child, and Ms. Wisenhunt will have the right to determine the primary residence of the child. There will be no geographic restriction, state standard visitation. Mr. Wisenhunt carries the child's medical, dental, and visual insurance, and he will be ordered to continue to do that. The child support will be $696 a month starting July the 1st. There's no retroactive child support, and court costs will be paid by December 31st, 2023. I'd like to call first Ms. Wisenhunt.
I have a question. I have a question first. On the record, Ms. Overstreet, you said that the father was going to provide medical, dental, and vision.
Well, he provides vision. Vision won't be in the order. I'm sorry.
Okay,
I
well,
was
then
just
let's
reading what I
make
had
sure for
written
the
down.
record being clear
Right.
that we're not going to have vision in the court order.
No, it's not. I'm sorry about
Okay.
that. I was
Go
just
ahead.
reading my notes. So I'd like to call is it Wisenhunt?
Yes, ma'am.
Can you state your name, please?
Heather Wisenhunt.
And you heard the terms of the agreement as I read it into the record?
Yes, ma'am.
And this is in fact your agreement?
Yes, ma'am.
And you're asking the court today to accept that agreement and sign off an order with those terms?
Yes, ma'am.
All right. Thank you. I have nothing further of Ms. Wisenhunt. I'd like to call Mr. Martinez.
Go ahead.
Can you state your name?
Apolonio Martinez.
And you heard the terms of the agreement as I read them into the record?
I heard. Yeah, I heard you say something about what's not in the record about vision. Could you clarify that for me? To the judge?
Okay, I didn't understand what your question was.
The question was that the judge asked for something and you said that you apologized for something that was
Oh,
not in the record.
I had said that you carried vision, and he just wanted to make sure I wasn't putting that section in the court order because that's not provided for in the family code.
You're breaking up, so I didn't understand what you said.
Okay.
Streamlabs doesn't yell at anybody
Vision
anymore.
will not be in the order.
So you're saying that that's required of me to hold on hold for the child?
No, it's not required by law for you to have the vision.
Okay.
Mr. Martinez, can you hear me?
I can hear you, sir.
Mr. Martinez, you are required by law to carry medical insurance on this child. You're also required by law to carry dental insurance on the child. You are not required by law to carry vision insurance on the child. Therefore, it cannot be in my court order because the law doesn't require you to carry it. You can still have it, and I would advise you to continue to carry it, but I can't require you to do that under the law, okay?
Absolutely. Now it's clarified. Now I understand.
Yes, sir. Go ahead, Ms. Overstreet.
Thank you, Your Honor. Mr. Martinez, did you agree with the terms of the order as I read them into the record?
I agree to all terms. As far as my child is going to be under the address that the mother spoke to you about, and I'm able to go see that child, my child is in the house.
Yes.
Because she's living with.
George, are you talking about Judge Webster? You don't know Judge Webster? How is that possible? Judge Webster is like my favorite. He hums. Oh my God. When you get a hum, like look at this smile on Judge Webster's face. This is a happy Judge Webster, okay? I am going to take a screenshot. Mark that time down because you don't see him that happy. I love it. He's one of my faves.
Because she's living with me right now because she ain't got a place to go.
Yeah, well, whenever she has a new address, it'll be in the court order. And she's provided to always update you. Well, it won't be in the court order, but it's in the court order that she's provided to provide the address to you.
Ms. Overstreet, just ask your question. Don't explain the law to the parties.
Okay. I have nothing further, Your Honor.
You have any other witnesses?
No.
Ms. Wiesnant, do you have any questions about this case before I approved the agreement with Mr. Martinez?
No, sir, I do not.
Mr. Martinez, do you have any questions about this agreement before I approve of it?
No, sir. Just my concern and with the issue of my concern about my child's well-being.
And how I can't address that, Mr. Martinez. You just told me that you agreed to the court order. Either you agree or you don't.
As far as right now, no, sir, I don't.
No, sir, you don't what?
Agree to the terms too.
Then let's have a hearing. Call your first witness, Miss Overstreet. Let's have a trial.
Thank you, Your Honor.
Baby,
I'd like
prove
to
it up.
call Miss Wisenhant again, Your Honor.
She's been sworn.
Yes, sir.
Okay. Ma'am, can you already stated your name for the record. Where do you live?
Right now I'm at Paul's because he has to come down here. I was trying to move back to Baytown.
Okay.
Right.
Now, where are you intending to live? What city?
I'm probably going to go back to Nome.
Okay. And that's in Jefferson County.
Yes, ma'am.
Okay. Now, and has the child always lived with you?
Yes.
Okay. And when did you move in recently with Mr. Martinez?
About 2 weeks ago, 2.5 weeks ago.
Okay.
Objection leading. She's like, oh, fucking desperately not wanting this case to go off the rails. Here's my theory on this, and I'm just going to be honest, okay? What happens is these cases follow a very standard pattern. Judge Webster used to be the attorney that did these cases. In my opinion, the lawyer has the absolute ability and honestly, what I would think would be the responsibility to look into this shit beforehand. But every time Miss Overstreet asks a question, sounds like she's getting the answer for the first time and she didn't know. And that's mistake number uno when you're a lawyer. Don't ask a question in court that you don't know the answer to. And so I think that's what frustrates him the most is because this information, if they went ahead and got it ahead of time, would be like it's baffling to me how often the information isn't correct.
And before that, you had lived in Jefferson County for quite some time. Is that correct?
Yes, ma'am.
And you had lived in Jefferson County for 6 months prior to us filing this suit?
Yes, ma'am. For about a year. Yes, ma'am.
Okay. And now, is Mr. Martinez a good dad?
Yeah.
Is that a yes or a no, Miss Wiesenoff?
Yes.
Thank you. No, yeah, and no, nah. Yes or no?
That was also a long pause before she said that. Let's go back. I just love him so much. I love you, Judge Webster. Look at that little sad face. Oh my God.
Yeah.
Is that a yes or a no?
And now, is Mr. Martinez a good dad?
Yeah.
Is that a yes or a no, Miss Wiesenoff?
Yes.
Thank you. No, yeah, and no, nah. Yes or no?
Now, okay. Now, does Mr. Martinez visit the child on a regular basis?
He did up to a year ago, and then.
Okay. So before you moved in with him a couple of weeks ago, when was the last time he had seen the child?
December 10th of 2021.
Okay. Now, in the 2 weeks that you've been there, do him and the child, they seem to get along and everything's fine?
Yeah.
Okay. So you don't have any problem with Mr. Martinez visiting the child overnight or anything?
None at all.
Okay.
No.
And now, the child is currently covered for medical insurance and dental insurance through Mr. Martinez's work.
Yes, ma'am.
Okay. Now, are you asking for any back child support or just child support going forward?
Just child support going forward, you slide.
Okay. And Mr. Martinez, as far as you know, does he have any other children under the age of 18?
Could you rephrase?
Mr. Martinez, Mr. Martinez, she hasn't called you as a witness yet, okay?
Okay.
But she did ask the question that way. Miss Overstreet, please direct your question at your witness and Zoom.
I did. I asked her if Mr. Martinez had any other children under the age of 18, as far as she knows.
Go ahead.
Could you ask
yes,
that
I'm
question?
saying it's confusing the witnesses.
Oh my God, this is fucking gold. Thank you, YouTube court, Jesus Daddy. Seriously, this is great. He doesn't have any time, but she is right. She did address that question properly. The problem is that they all don't. He is rude to her. I call it judicial efficiency, but he has literally no room for error with him, and she is upset because I think we'll go back actually because we do have instant replay, and I think Judge Webster I don't know what he's gonna argue here, but let's go back, watch this replay, and he shouldn't have spoken up. Usually he zips out at the people, but here's the thing, Judge I bet knows he can't hear him so good, so I don't know. Okay, here we go. He did look confused. Look at his face. I love it.
Just child support going forward, you slide.
Okay. And Mr. Martinez, as far as you know, does he have any other children under the age of 18?
Okay, never mind. I'm wrong. He was right. That was confusing. She should have prefaced it differently.
Could you rephrase
Mr.
yeah,
Martinez,
question?
Mr. Martinez, she hasn't called you as a witness yet, okay?
Okay.
But she did ask the question that way. Miss Overstreet, please direct your question at your witness and Zoom.
I did. I asked her if Mr. Martinez had any other children under the age of 18, as far as she knows.
Go ahead.
Could you ask
Yes,
that
I'm saying
question?
it's confusing the witnesses. They're not sure who it is that you're asking the question to. Mr. Martinez.
Miss Wisenhant. Oh,
Yeah.
I'm sorry, Judge. I thought you were through.
I was.
Miss
Mr. Martinez, I'm not done. Mr. Martinez, please do not talk until somebody asks you a question and I tell you that it's your turn to speak, okay?
Yes, sir.
Thank you, Mr. Martinez. Go ahead, Miss Overstreet.
Thank you, Your Honor. Miss Wisenhant, as far as you know, does Mr. Martinez have any other children under the age of 18?
No, ma'am, not that I know of.
All right, thank you. Your Honor, I have no further questions of Miss Wisenhant.
Vicky, if you've seen this today, that is you're on it, because this aired today and this is my first time seeing it, so damn. They do go at each other. I think he respects Dana Overstreet, though. The one who he scares shitless is Miss Simone. I have a funny feeling that poor woman's name isn't even Miss Simone, but she was afraid to tell him that's not how to pronounce it, and she's just gone with it now and changed her whole life. Because it's spelt Simon.
I'd like to call Mr. Martinez.
Okay, go ahead.
Mr. Martinez, where are you currently residing? What county?
I reside in 1001 Largo Street in
No,
Baytown,
Mr.
Texas.
Martinez, Mr. Martinez.
Well,
The question
fuck.
is, what county do you live in? Not what your address is.
Harris County.
Thank you.
Thank you, Your Honor. Where are you currently working?
I work for Target Resources.
And what do you do there?
I'm a truck driver.
And are you paid salary or by the hour?
Hourly.
And how much do you make an hour?
$26 an hour.
Did you say 26?
$26 an hour, correct.
Thank you. And how many hours a week do you work?
40 hours a week guaranteed.
And do you ever get any kind of overtime?
I've had overtime. Yes, I've had.
Okay. How often do you get overtime?
Not often enough, but I get some.
Okay. Now, you're currently covering the child for medical insurance.
Correct.
How much is it costing you a month for that medical insurance?
It's close to $600 a month.
And how many people are on it?
The child and myself.
Okay. And you don't have any other children under the age of 18, do you?
No, ma'am.
Okay. Now you're also covering the child for dental. Is that correct?
Correct.
And how much is that costing you a month?
I don't know the exact number, ma'am, but the vision, dental, and all that, it's close to 600 altogether, bundled in one insurance.
Okay. Okay. So all of them are the 600 a month, and you and the child are the only two on it, right?
Right.
Okay. And Your Honor, I have nothing further of this witness.
Call your next witness.
I have no further witnesses.
Uh-huh. So, Ms. Wiesnant, is there anything else that you think I need to know about this case before I make a ruling? Ms. Wiesnant, is there anything else that I need to know about this case before I make a ruling?
No, sir.
All right. Mr. Martinez, is there anything else that you think I need to know about this case before I make a ruling?
Just a concern, Your Honor, that I have for my child and where he's going to be staying.
What's your concern? Tell me what your concern is.
Well, she says that she's going to go back to stay with her daughter at that address.
Okay.
And but she told me that her daughter didn't want her there.
Okay.
I haven't heard anything from them since the day that she just mentioned. I haven't heard from my son. She ain't called me. She ain't let me know anything about him.
Now, she did say that you hadn't. She did say that you went almost a year without seeing him. Why did you go a year without seeing him?
Is that question to me, sir?
Yes, sir.
She didn't, because she would never call. My son has had a phone for a year and a half, and I've called him and I've texted him, and he's never replied. So I never knew where they were at.
Okay.
I would send text messages to find out where they were at.
Did they move? Did they move, Mr. Martinez, and you didn't know about it?
I didn't know anything. I didn't know their existence or whereabouts. She would never call me, let me know where they were. So
when you were seeing your son over a year ago, how were you going about seeing him? Did you go to their house and pick him up? What happened?
Yeah, we had a total agreement where we was going to keep the state out of it. I would give her her child support.
Hey, Mr.
Martinez,
Martinez.
she was real good about it.
Mr. Martinez.
Yes, sir.
Can you hear me?
I can hear you good.
I want you to listen to the question that I asked you, and I want you to answer the question that I asked you. I don't want you to answer the question that you want to answer. I want you to answer the question that I give to you.
Okay.
You had been visiting your child all the time up until a year ago? Yes or no?
Yes.
Did you go to Miss Wiesnant's house and pick up your child?
Yes.
So you knew where they lived?
Up until a year and a half ago.
All right. And then they moved?
Yes.
Did Miss Wiesnant tell you where she moved to?
No.
Okay. See, that's a problem. Miss Wiesnant, why didn't you tell Mr. Martinez where his child was? Miss Wiesnant, I've asked you 3 questions in the last 5 minutes and you haven't answered but one of them. Can you hear me?
Yes, I can hear you.
Are you moving around? You in a moving vehicle or something?
No, I'm sitting outside.
Because I can't hear you hardly at all. Nope, I can't hear Miss Wiesnant at all.
And I'm assuming she can't see my middle finger.
Oh.
I can barely hear you, Miss Wiesnant.
I mean, I can hear you fine. I don't know.
There you go. Whatever you just did, don't stop doing what you just did, because now I can hear you.
Put it on speakerphone.
Yeah, whatever you just did, don't change it because it's working.
Okay.
Why am I on a speakerphone?
Because it wasn't working the other way.
Oh,
I had it on regular.
okay. All right. So you moved and you didn't tell Mr. Martinez where? Why did you do that?
Because we were only staying at 3 months at a time. We had a hard year. We'd move, and there was a lot of stuff going on. There's no real good reason. So there's no good reason.
Yeah, because you broke up his relationship with his son.
I understand.
You can't do that.
I know.
All right. By law, Mr. Martinez, Ms. Wiesnant is required to tell you where she lives, and she's to inform you by law within 30 days before she moves of her intention to move to a different address. Do you understand, Mr. Martinez?
Yes, sir.
Does that alleviate your concerns?
Yes, sir.
All right. Ms. Wiesnant, is there anything else that you think I need to know about this case before I make a ruling?
No, sir.
Mr. Martinez, is there anything else that you think I need to know about this case before I make a ruling?
No, sir.
Ms. Wiesnett, do you have any objection to me looking at the acknowledgement of paternity for the
I
child,
do.
Matthew?
No, not at all.
Mr. Martinez, do you have any objection to me looking at the acknowledgement of paternity for the child, Matthew?
No, sir.
State's Exhibit A is admitted into evidence. Based on the testimony of the parties to this case today, the court's going to find that it is certainly in Matthew's best interest to name the parties as joint managed conservators. With Miss.
Would Larry Beaver please report to the office, please? Larry Beaver, report to the office. Thank you.
Wiesnett with the right to establish the primary residence of the child with no geographic restriction. Mr. Martinez will be awarded visitation at any and all times mutually agreed to by the parties. If no mutual agreement, then stand in possession. The father will be ordered to carry the health insurance and the dental insurance on the child. I gave him $250 per month credit toward the child support on the health insurance and $50 a month credit toward the dental insurance. Based on my calculations with no other dependents, I'm going to find that Mr. Martinez's child support will be $695 per month, beginning July the 1st of 2023. There'll be no retroactive child support in this case, and Mr. Martinez will be responsible for court costs, but I will give him until December 31st of 2023 to pay my court cost. Ms. Overstreet, did the state of Texas hear all the terms and conditions of my court order?
Yes, Your Honor.
Do you have any questions, Ms. Overstreet, as to the form?
No, Your Honor.
All right. Ms. Wiesnett, Mr. Martinez, what's going to happen now is Ms. Overstreet's office is going to send me an order. If it matches what I said here today, I'm going to sign it and I'm going to return it to them, and then they're going to make copies of it and they're going to send it out to each of you. Okay.
Yes, sir.
All right. I appreciate you both being.
What did you appreciate about that, Judge? Now I'm interested to see what the other hearing was like that day. Oh shit, that was the last one. Okay, interesting. Well, let's start here. Maybe this is the one we just watched and I downloaded it twice. I do that sometimes. Nope. But also, guys, last thing. I love getting new subscribers. Y'all know I dance in my kitchen when I get them and I love it. And I just want to let y'all know that this is the way that I like the channel to be. The lives are my commentary, me jumping in, talking a lot, yelling, throwing up beavers, you know, all the stuff that we do when we're live. And that's not really going to change. And it's not the most popular thing to do. And that's okay. That's not why I do it. I do the shows that I do because I like them. So I just want y'all to know that as the channel grows, the videos that I put out will likely be more mainstream, less beaver, and the lives will stay beaverific.
This court's going to call cause number C232020. This is in the 317th District Court of Jefferson County, Texas. And it's in the interest of Reginald and Amari Slaughter. Miss Sierra Neville, I need you to unmute and raise your right hand. Miss Neville, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can put your hand down. Reginald Slaughter, would you unmute, please? There you go. Raise your right hand, Mr. Slaughter. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you, sir. You can put your hand down. Do you have any other witnesses, Miss Alexander, besides the parties?
Yes, Your Honor, Miss Kim Shaw.
Kim Shaw, please raise your right hand. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you, ma'am. You can put your hand down. All right, you can call your first witness.
The state would call Miss Neville. Miss Neville, what is your full name?
Sierra Neville.
And what are the names of the children before the court today?
Amari Slaughter, Reginald Slaughter Jr.
And what is Reginald's date of birth?
12/17/2008.
And what is Amari's date of birth?
March 16th, 2016.
Okay. And Was there a prior order that was done in this case, approximately June of 2021?
Can you repeat that? I'm sorry.
Was there a prior order that was done in about June of 2021 that based child support on minimum wage?
Also, we can't figure out her accent. Miss Alexander's accent to me sounds like she literally, I have this backstory for her in my head that she like has some sort of, I don't know. I think it's like New Zealand, but she left when she was really young. Or maybe she was raised in Africa with parents with accents. Or, like there's just some weird story because just, you know, it's not, an accent as, well, it's definitely not and it's not a Texas twang that I've heard before. Let's put it that way.
Yes.
Okay. Your Honor, the state would ask the court to take judicial notice of the court's file, specifically the order that was entered June 22nd, 2021.
20 order. 20 order. Did you hear that? That's the accent. And that's why it's not like a speech impediment. She's had an accent.
Or take judicial notice of its own file.
And you were
No, but listen, I was born in Scotland. My family is Glaswegian. I know accents. I'm saying it is the faintest of the faint. She's not British. She's not even pretending to be British. Nobody would if she's been British, it's maybe South African, but again, what I'm saying is the accent is so fake, or not fake, like so minute that she probably doesn't think she has it.
recently had what's called a child support review process in our office, and Mr. Slaughter was there, and an order was put together, what we would call a non-agreed. And in that non-agreed, it set the child support at $980 to start June 1st, 2023, with a step down of $765 when the oldest graduates. Are you asking the court to approve of those terms?
Yes, ma'am.
Okay. And in that order, it's going to have dad cover the health insurance and the dental insurance through his employer. Is that what you're asking the court to grant?
Yes, ma'am.
And all of the other terms, there's not too many, you're asking the court to grant that order. Is that correct?
That's correct.
Asking. Do you hear how she's saying that? Asking? That's asking. That's not British. Believe me, first of all, I am Canadian. Also, I did tech support and billing support for AT&T. So I've talked to like Americans from everywhere. And I've worked in tour. Oh man, the AT&T is the best one. What about the like 5,000 passengers on cruise ships that you dealt with all week? Oh yeah, okay, that one too. Also, I was married in Texas.
Right.
And you actually did sign on that order. Is that correct?
I did.
Okay. No further questions, Your Honor.
Call your next witness.
The state will call Mr. Slaughter. Mr. Slaughter, what is your full name?
Reginald Slaughter.
Okay. And do you agree that in approximately June of 2021, there was a prior order that set your child support based on minimum wage? Is that correct?
Yes, ma'am.
Okay. And we're looking to modify that order today. Is that correct?
Correct.
Okay. And where do you currently work now?
City of Beaumont.
Okay. Now, in that non-agreed that we filed, we have your monthly gross income as $5,771. Do you agree on that monthly income?
Yes, ma'am.
Okay. And we gave you credit. You cover the health insurance through your employer with a cost for the children with a cost of $204.98. Is that still about right and what you agreed to?
Yes, ma'am.
Okay.
Oh, listen, I'm not surprised she has a Texas twang on certain words, but looking is not, it's the way she says ing words, okay? It's it's a very interesting way of not pronouncing the G. And she does it on more than just looking, asking, and a few others. I don't think it's fake. I've watched very many hearings with her. It's never wavered or changed. It's always puzzled me. And I really just think she was raised by somebody who had an accent and maybe lived like overseas until she was like 3 and then lived in no, yeah, but lived in Texas but had parents with an accent. That's my theory.
And for the dental, there's a cost monthly of $17.90 for the dental. You agree with those dollar amounts?
Yes, ma'am.
Okay. Now, do you agree to the actual calculation?
But she does not have any quirky terms of phrases. I've been on the lookout, guys. This is literally one of my biggest figure out ones that I want to figure out, because I listen for Australian or South African. I really thought New Zealand or even like South African parents, and again, or Africa. I really think Africa. But I'm getting the sense that she is in Texas. I don't know. I have a whole backstory for this lady in my head.
That we came up with based on guidelines support of $980.
So you asked me earlier, I said yes. I was looking at my net. So from the gross, when I take home from after they take taxes and deduction, I take home approximately $3,922. So if you do the percentage of the $980 that's being requested for child support, that's still coming out to nearly 25% out of my check, out of net.
So, what I'm asking is, would you agree that based on what I calculated for guideline support, it would be about that much, but you don't agree to the actual amount?
Correct.
Why? Can you let the court know why?
Okay, I explained one of the reasons just now. So my net take home is $3,922. When you do the percentage of $980 off of that, it's still 25%. It's still not accounting for any deductions. One of the deductions is me having another child. I believe there's supposed to be a 3% deduction on that. And also whenever I have the kids, I still have expenses when I have Amari and RJ.
Okay, and so what are you asking the court to set the child support amount at?
I was asking for $750, somewhere around that ballpark. Nothing too low because I still want to support my kids. I'm not trying to lowball or anything like that. Just I still have expenses. I still have things that come out of my check. I still have to pay for lots of things on my end, and I feel like
Judge Webster wants desperately to break in. And what I was going to say is there are people like me who have a hard time not talking. And so as lawyers, even though you probably like lawyers talk a lot, that's oftentimes why you should become a lawyer. But in reality, being able to hold your tongue and listen is a hard skill for even some lawyers. So you'll find what I find is there are certain people that use a physical reminder of that for themselves. So Judge Webster over here literally puts his hand like that and I think clamps his jaw shut. He is shaking. When I unpause it, you'll see that it's shaking. And what I imagine he's like down below the desk moving his legs. I think that he appreciates the rules because he enforces the rules and he knows he's not to step in and explain this to the guy. But my theory is that he's going to jump in and say, yeah, and she has expenses when she's got the kids and blah, 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 blah. But he's letting Miss Alexander see. I think he has a little bit more respect for Miss Alexander. And she doesn't strike me as not knowing the answer sometimes. Sometimes people surprise. Yeah. Anyways, let's just continue. Just shut up, Kitch.
750 would be enough to take care of that. So my youngest with Sierra Amari, she's no longer in daycare. That was one of the biggest expenses that I know she had when I was paying child support when I was working. Now she's not in daycare. I believe those expenses are cheaper, you know?
Okay. Do you understand that the calculation that we
Robert
have, it is
Romano,
based
you're
on
talking
value?
about Rocket Robert Romano from ER who had a feud with helicopters. He does look like Rocket Romano, and he is like Rocket Romano as a judge. Just brash and abrasive and like, well, fuck you.
On child support, you're just asking the court to set it lower because you have other expenses. Is that what you're asking?
Yeah, I understand that.
Okay. No further questions, Your Honor.
Mr. Slaughter, how many children altogether do you have?
Three.
Okay.
I'm sorry, how many?
Three. Two with Miss Sierra, and then I have one outside as well.
All right, so while we're talking about it, you fill out your taxes every year, Mr. Slaughter?
Yes, sir.
How long have you been back with the city of Beaumont?
About a year.
Okay.
Year and a half.
So I mean, a year and a half.
Yeah. I started in January.
January of 2021?
No.
2022.
Correct.
Okay. So 6 months after I did the court order that lowered your child support to $250 a month, you went to work for the city of Beaumont.
Correct.
And you've been paying lowball child support for a year and a half.
I was on a adjusted, so I was a police cadet, and I was still making pretty much.
Were you?
To use a Texas turn of phrase, that dog don't hunt. Y'all, that dog don't hunt for Judge Webster. You went and got another job? No. Nuh-uh, that dog don't hunt.
Making $1,256 a month?
No, sir.
Yeah. So you've been lighting the low for about a year and a half. Let's be honest about it.
And I was paying my arrears as well. I had a lot of debt that I was paying off.
While I understand what you're talking about, Mr. Slaughter, it's not my responsibility to make sure that all you.
Thank you, Mayor. Thank you, thank you, thank you. And welcome, Vicky, to the club. You've got all the emojis now. That's awesome, Mayor. Appreciate you doing that. I know it's hard with your tiny gnome fingers.
Your other bills get paid. It's my responsibility to make sure the child support is supposed to be set the way it is. Okay.
Okay.
So let's just be honest. For a year and a half, you paid a lot less child support than what you were supposed to pay.
Okay.
All right. And now the state's asking me to increase your child support to $980, and you want me to increase it to $750. So
Yes,
you
sir.
said, Judge, I want you to base my child support on $750 because I got a lot of other bills that you're responsible to pay. What bills do you have to pay?
I pay daycare, Pampers, wipes, other expenses for my 3-year-old.
Okay, is your 3-year-old live in the house with you?
Yes.
Okay. Well, I mean that is what it is, that you have another child. The law requires, Mr. Slaughter, that I give you credit for the dependents that's in your household, and I've done that. Your child support is not as high as it would be. It's only set at 22.5% instead of 25%. So you did get the 2.5 reduction that the law requires that I give you.
Okay.
All right. So I mean, it's the nature of having another child in your household. You're just going to have to absorb that expense. But the law does.
I'll tell you what's cheaper than Pampers and wipes. Wrapping your dick up before you stick it in her.
Cry gives you credit for that.
Okay.
All right. So you said that the one thing that you actually started talking about at the beginning was that you were concerned that what you bring home is not actually what I'm using to set your child support on.
Yes, sir.
So the law says that I set your child support based on your net disposable income.
Okay.
The Internal Revenue Service publishes a data sheets for me every year that tells me exactly what somebody brings home based on their income. So you do make your gross is $5,771 a month, correct?
Mm-hmm. Yeah.
The Internal Revenue Service says the only thing that the federal government requires you to pay on $5,771 is $1,066.14. The Internal Revenue Service says that's all the taxes that you pay on that. Now, if you have a lot of other deductibles.
Hold on, we need to go back. Canadian here, don't understand. Did he means for the month, right? Not the year. He does not mean for the year. He absolutely does not, right? He does not. He does not. Come on now. Come on now, you. You don't want to know what we pay in taxes.
Internal Revenue Service says the only thing that the federal government requires you to pay on $5,771 is $1,066.14. The Internal Revenue Service says that's all the taxes that you pay on that.
Per month. Okay, that's fine. That's cool. I thought you were talking that per year. I was like, you fucking kidding me? And yes, I was born in Scotland. I came to Canada pre-accent, but I still understand Scottish accents, luckily. And yeah.
Now, if you have a lot of other deductibles coming out of your check besides that $1,066, I'm not supposed to consider that.
Okay.
If you pay more income taxes than what you're supposed to pay, then you get a check back at the end of every year from the Internal Revenue Service because you overpaid your.
Do you know how messed up, Polly? You think that Karen Alexander is from Scotland? I mean, the name is very Scottish, but do you really, could that, oh my God. Oh my God. Wouldn't that be the full circle mind fuck in my head? Because I'm born in Scotland. You think I could fucking identify the accent? Polly? Wow. I'm ashamed right now. I'm hilariously ashamed. I mean, she's not from my part of Scotland, I'll tell you that much.
Your taxes, right?
Mm-hmm.
So, because.
Wait, do I sound like that? Is that my accent too?
Because you overpaid your taxes doesn't mean that you're not supposed to pay child support on that.
Okay.
Now, you get retirement that comes out of your check.
Correct.
You still have to pay child support on your retirement. Just because you decide to take money out of your income and put it to a.
If that's true, if she was born in Scotland, grew up in England, and moved to the US in 2009, she is a huge faker. She is absolutely under accenting. There's no way. Nobody born in England and lived there till adulthood. I believe you, Polly. I don't think you're lying. Now I'm worried. I'm concerned about Miss Alexander. Somebody's going to have to check into that because no. Seriously. Richard, I'm right? Like she couldn't. Where? She would have to be trying so hard to unaccent herself.
Later date for you to be able to draw because you're no longer working doesn't mean that you're not supposed to pay child support on. You are. You're supposed to still pay child support on your retirement. Okay.
And I'm not trying to be offensive here at all. Judge, I'm not done. Okay? I'm dealing with something right now. I'm not trying to be rude here, but in 2009, Miss Alexander was not a teenager. No offense, Miss Alexander. But that's just not impossible.
You just decided not to take it now. You're going to take it later when you retire. You still follow me so far?
Yes, sir. I'm still listening.
All right. You see, while I do understand what you're saying, the law doesn't allow for me to give you credit for all these additional expenses that come out of your check. The law says,
Okay.
Judge, this is how much money Mr. Slaughter earns a month. This is how much money the Internal Revenue Service he's supposed to pay in taxes. And you're going to set child support, Judge, based on the rest of it. Okay?
Okay.
Y'all hold on, because I saw something in this deal I didn't like.
It would make sense to me that she learned her law in America because of her usage of the terms. And she doesn't default to any, well, maybe she just knows the Texas people can't handle it.
Miss
On. Here's the thing, what happens with Texas people, they don't even realize it happens, and it's not a bad thing. But if you put somebody in front of them who is audibly from a different place, like England or even Canada, if they can pick up on it, they just get so nice and like invite you to their house and like make sure that you're all good. And seriously, it's actually, I bet what's happened is she is found that if she doesn't mask her accent, she gets treated just totally differently and she has to get work done. She can't get anything done because court stops, all the stuff happens. So I that's actually probably what's happening. I think that's where it is.
Miss Neville, can you unmute?
Yes, sir.
Right. In the interest of trying to conduct hearings in good faith, I'm going to ask you this. Now, Mr. Slaughter says that he really wants to pay $750. I will tell you, based on my calculations, I do get $980. That's what I came up with. I mean, it's within pennies of what's being suggested. Okay. The law does allow me, however, to reduce that if you're willing to agree, just solely based on the fact that Mr. Slaughter does have another dependent in his household that may cost more money than what the law allows. I can do that if you wish me to do that. You do not have to agree. You can say, no, Judge, I got 2 kids and I'm entitled to $980, and that's what I want you to do. Okay? That is your right. You want me to set the child support at $980, or you want me to set it at $750?
$980, sir.
That is your right. I can set the child support based on that information. Thank you, Ms. Neville.
Thank you.
Ms. Neville, are you still in the service?
Service?
I thought somebody was in the service. It may have been an old order I was looking at.
Okay.
Anything further from the state?
Nothing further from the state, Your Honor.
Mr. Slaughter, is there anything else that you think I need to know about this case before I make a ruling?
No.
Mr. Slaughter, can you please change your smoke detector alarm? That's an order of the court.
I'm going to change 2 things in your court order, Ms. Alexander. The first is the start date on this case is going to be July the 1st.
Sure.
Instead of June the 1st. I mean, we're already on June the 8th. Mr. Slaughter's already missed at least 1 paycheck. So the other thing I'm going to change is, are you looking at your court order, Ms. Alexander?
Yes, I am, Your Honor. I know exactly where you're going.
Page 7. I think you need to change those percentages, don't you?
I for whatever reason, I overlooked that. I mean, I looked at the calculations.
Hey,
yeah,
you
it
know
should be
what? I
20.
don't always catch it either, Miss Alexander, but I just had spent enough time looking at it and thought, I don't think that percentage is correct.
I looked at that and I'm like,
Anything further in regards to this case, Miss Alexander?
nothing further, Your Honor.
All right. Mr. Slaughter, Miss Neville, what's going to happen now is Miss Alexander's going to send me an order. As long as it matches what I said here today, I'm going to sign it and get it back to them. Then they're going to make a copy of it and send it to each of you, okay?
Okay.
All right. I appreciate you both being here today. Mr. Slaughter, those were really good questions. And I do understand what you're saying. They're, right now the law is what it is. And so I'm required to set child support based on your income, okay?
Hey, I got all I had to do was ask, and I got my answer.
Yeah, and don't ever be afraid to ask.
Yes, sir.
Good luck to you both. You're both free to go. Have a great day.
You too. Thank you.
That's an example of a hearing he liked. Okay. Last one of his, and then I'm going to talk about a few little things before I have to sign off because it's been almost 4 hours. Shh.
This court's going to call cause number C-237-847. This is in the 317th District Court of Jefferson County, Texas. It's in the interest of Casey and Taylor. Miss Jeanette Lee, would you raise your right hand for me, please? Miss Lee, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, ma'am. You can put your hand down. Miss Alexander, you handling this case for state?
Yes, I am, Your Honor.
Do you have any other witnesses besides Miss Lee?
No, Your Honor.
All right, let's check some service and see if we're able to go.
Kim, your hair's fine. Your hairspray's holding up.
Court's going to find that on April the 14th, 2023, Mr. Taylor was personally served with citation in this case in Jefferson County, Texas. That citation was returning on file with the district clerk's office. Oh, let me see. It looks like on April the 26th of 2023. He has not filed an answer nor otherwise made an appearance in this case. Let's see if the state sent him notice of the hearing.
It's an invisibility cloak, but he's got it on the wrong way, so we just can't see the cloak, Crystal.
Court's going to find that an email was sent to Mr. Taylor at an email address that matches his name. Therefore, I'm going to allow this case to go forward by default. Now, Miss Alexander, it appears this is what we like to refer to as a non-agreed child support review process order for modification. Is that correct?
Yes, Your Honor.
All right. So he was served in April. Looks like you filed this all the way back in December, but it looks like you had a little trouble getting him served. That happens. Now, Miss Lee, you and I spoke before we got started on this case, and I kind of told you that I was willing to go along with this order, but I would probably have to change the start date on the modification because the law does not allow me to go back in time and modify the child support. You understand?
Yes, sir.
Knowing that I can start this new child support figure as of May the 1st of 2023, are you still in agreement with the order?
Yes, sir.
All right. Ms. Alexander, does the state object to me changing the start date of the child support?
No objections from the state, Your Honor.
Otherwise, we're going to sign the order as whole.
Yes, Your Honor.
All right. Do you have any objections to me doing that, Miss Lee?
No, sir.
All right, that's what I'm going to do. Miss Lee, I'm going to announce that I'm going to sign the court order as proposed to me, except for the minor change of the start date being May the 1st instead of the start date that's in the court order. When I sign it, they'll send it to me and I'll sign it. And then I'll send it back to them. They'll make a copy of it and send it to you and to Mr. Taylor, okay?
Yes, sir.
All right, do you have any questions, Miss Lee?
No, sir.
All right, well, you have a great day.
You too. Thank you so much.
Thank you, ma'am.
Bye.
Oh, that one was quick, Judge. I'm just looking something up, but that's okay. That's okay. I remember there was a real goodie in here, and I'm trying to remember which one it was. It was a different judge as well. Him, no. Her, no. Him, maybe. Let's see if this is it. No, that's not it. We watched that. What are the odds of opening something that we already watched? Mm, let's see what this. Oh, this guy looks funny. What's up, guys? Welcome back to Kitchen Court Case. I don't think I posted this video. I think I made it, but I don't think I posted it yet. Oh no, I did. I totally did. Never mind. We'll watch something different. That means that it was a downloaded one. Oh, this one. What is Nana watching? Okay, yeah, this will
Hey, everyone.
be
Yeah.
the same one that I already watched. Okay, well, we're running out of shit for today, guys. I'm just kidding. What I was looking at, actually reading, was a guy that was arrested in Canada and jailed for like, his hold on, let me pull up the article here. If you are bored, go ahead and leave. If you are interested in what I'm going to say, then just give me 1 second. Make sure you've hit that like button. There's so many buttons in front of my face. Where is... Okay. So what this guy was jailed recently for his for contempt of court. And yeah, here we go. Here we go. Got it. I will put it over here while I read it loud for us, and then we will be done. Give me 1 moment. And so this is actually in British Columbia, where I am from, British Columbia. So this is from CBC, which is the Canadian Broadcast Corporation. And the headline says BC judge sentences man to 1 year in jail for contempt of court. The courts of British Columbia are legitimate or they are not. There is no middle ground, said the judge. So, a provincial court judge in Prince Rupert, BC, has sentenced a 46-year-old man to a year in jail for contempt of court, ruling he tried to circumvent the justice system with pseudo-legal and stupid arguments. Judge David Patterson sentenced Cameron Hardy in part to deter others from subjecting the court to the theory known as organized pseudo-legal commercial arguments, which is basically SOV6. Patterson's ruling details how Hardy, who was facing a charge of resisting or obstructing a peace officer in 2021, considers himself a free man, meaning he won't accept that courts have jurisdiction over him and falsely believes Canadian law doesn't apply to him. The courts of British Columbia are legitimate or they are not. There is no middle ground. There are no shades of gray, Patterson's ruling says. Unfortunately for Hardy, the courts of British Columbia, including the Provincial Court of British Columbia, are legitimate. Hardy, who represented himself in court, was charged with contempt in the face of the court for refusing to recognize the court's legitimacy or to follow the court's orders and take part in the trial process. Misinformation in the courtroom. In his reasons for sentencing on the contempt charge, Patterson found Hardy displayed flagrant disregard for court's directions and orders. He found Hardy's legal arguments could be harmful to the justice system by turning routine matters into time-consuming exercises, and his arguments were not merely legally false, but often just plain stupid. Hardy's defense was vexatious and frivolous. He had no hope of success, thus, logically, his only purpose was to frustrate the court and waste government resources. Patterson ruled that Hardy intended to harm or deceive the court with nonsensical legal theory. It seems that phraseology such as post-truth and fake news has become increasingly prevalent in public discourse, Patterson's ruling says. As a court system, we need to recognize how the growing abundance of misinformation influences people in the political, technological, and societal context, including the courtroom. The ruling details how Hardy was first arrested in Prince Rupert in May 2021 and charged with one count of resisting or willfully obstructing peace officers in the execution of their duty. Days after his arrest, Hardy was released from custody under the condition that he wasn't allowed within 10 meters of a Prince Rupert liquor store. In later virtual court appearances, Hardy repeatedly challenged the court's jurisdiction over him, saying he was not a person. I am a man, commonly called Cameron Hardy. His first trial date was set for September 3rd, 2021, but Hardy wasn't allowed in the courthouse when he refused to wear a mask. At the time, the judge asked him over the phone if he had a letter from a doctor confirming he was unable to wear a mask for the short walk between the courthouse entrance and the courtroom where the trial was scheduled. I don't need another man or woman's permission to breathe, Hardy replied. I've been breathing my entire life on my own. The court eventually issued a warrant for Hardy's arrest for not appearing in court on the set trial date. Patterson's reasons for Hardy's sentence lays out a timeline for several court dates derailed by his pseudo-legal arguments. Patterson made a ruling disallowing Hardy to file documents or make any pseudo-legal arguments at trial, telling him they wasted the court's time and taxpayers' money and had no chance of succeeding. My ruling made no difference to Hardy, Patterson's ruling said. He seemed more interested in doing what he could to stop the trial from proceeding and putting on a show for his numerous acquaintances, the judge says. The judge says he didn't order a psychiatric assessment because he found Hardy to be intelligent but an anti-government ideologist. I keep saying, what? What did I read wrong? But anyways, what do you guys think about that? Isn't that crazy? So that happened just in April of this year, 2023, and that is in my province where I live. So a year in jail is actually quite a long time. I mean, the judge is, I actually will look for the entire ruling and I will see if I can read it one day for us. But I don't search. I always like to look at the comments on news articles, but they don't always have them. Now I can look at the chat. I think it's great that they, well, he sort of did charge him for the wasted time because he put him in jail for a year. That's a lot of time to pay for wasting the court's time. I mean, I don't think that this is a case where he's sentencing him something and then gonna let him apologize and get out early. Like, this is a written decision that came down. So I thought it was very interesting. It came from the provincial court. We have 3 different court systems in British Columbia, where I am from. And so it does work similar to state courts, but we don't have any sort of cameras in the courtroom in the same way. So we would only know this via media requests, and they do like pictures, artist drawings. Anyways, let's see. There's nothing actually that's close to the proper, like, that story. Sometimes they have connected stuff and sometimes this one. No, that's not the one. There's one other case that I want to read about here. This is not the one, though. The one I'm talking about, give me one second while I grab it, because it is also very, very interesting and happened here. Okay. Where is it? Here we go. So this was a case. Where is it? Yeah. So this is the case of a BC man jailed again for refusing to remove a revenge website that targeted his ex-wife. So a Burnaby man convicted of harassing his ex-wife with a vulgar website and torrent of threatening emails is headed back to jail for continually refusing to pull the site down. Patrick Fox, an absolute piece of alleged, no, he's convicted. A piece of absolute alleged trash, only because whatever, but now you're a piece of trash, was sentenced in Vancouver on Monday to 1 year and 4 months in jail for breaching his probation. He was charged after leaving the website up and running despite multiple court orders to take it down after his original jail term. After credit for time served, Fox has 6 more months left in his new sentence. He was first sentenced to 4 years in prison in 2017 for an online harassment campaign tormenting his ex-wife. The website falsely labeled his ex-wife, who I'm not going to name, as a white supremacist, a child abuser, and a drug addict. The site, which has now been up for 7 years, and if that's her picture, we need a Larry Beaver. I'm not putting her picture up. His picture can absolutely go up. I'm not putting her picture up on here. Absolutely not. She did nothing wrong. No. Thank you, Larry. Appreciate that. What does the fox say? I'm a loser, I'm a loser, I'm a loser, I'm a loser. Okay, so the website falsely labeled his ex-wife as a white supremacist, child abuser, and drug addict. The site, which has now been up for 7 years, calls her a horrible, lying, sociopathic monster and also contained intimate photos. He used Google Ads to direct internet traffic from workplaces and neighborhoods near her home in Arizona to his website. After credit for time served, he was released after spending 2 years in prison. He was supposed to remove the website and remained on probation for 3 years. Last August, after another run-in with authorities, he said he would never deactivate the site. They can lock me up for the rest of my life, but I will never take down the website, he said in a post. Yeah, I'm not showing her picture. CBC, shame on you for showing it. Why would you even fucking do that? Get some fucking beaver balls. He was arrested again in Vancouver last September. His sentence Monday also includes another year of probation. The probation order includes protective conditions regarding his former spouse and her family, and he has also been directed once again to remove any websites in her name or directed at her, the Crown said in an email. Authorities have been unable to remove the website because it is the revenge website because it's operated through a server in a foreign country. I'm sorry, can we not get on that? I'm sure we can get that. I'm sorry. I don't know why authorities can't do it, but I'm pretty sure we can get somebody that can do that. I'm not actually kidding. That seems like a very anonymous good deed to do. The time of his 2017 conviction, a BC Supreme Court justice described the harassment as boundless. The court heard that Fox sent hundreds of thousands of emails to her. Jail him. Why is he? Wow. And people she knew. The court also heard how Fox allegedly bragged that he copied 600 to 1,200 people, including coworkers, on emails that insulted her and detailed her personal life. In one email, he promised to run her life and destroy her slowly and incrementally. She lost her IT job in 2015. She was told security risks posed by his behavior were part of the reason for job loss. That can only be in America because that's not happening in Canada. You're not getting fired because of that in Canada. It was a landmark case in how criminal harassment charges are applied. Are you joking? How do you call that a landmark case? He's obviously not learned a goddamn thing, and I wouldn't be wanting to hang any sort of hat after this. Get it taken down. Like, what? You're joking. Oh, now I have a new problem to deal with. She was told, yeah. He was a landmark case in how criminal harassment charges are applied in Canada as he only attacked his wife online. The case was also one of the first Canadian attempts to use the charge of criminal harassment to counter online attacks, and it failed, as I assume. Again, I'm thankful that they don't detail out the actual. Oh, don't! Him. That's who we'll leave up. So, what would the judge do? What do you think some of our judges would do with this in front of them? What do you think? What do you think? I don't know. What would you do? What would the judges do? Also, Nana is watching something so loud. I'm sorry. Anyways, I don't like this dude. Okay. So many things that Great. I get distracted by the news. Okay. I love you guys all so much. It has been a wonderful evening. It's been over 4 hours. Don't tell anybody. I love you so, so much. I appreciate all of you. I really enjoyed watching videos tonight and chatting as usual. I said it last night, but I mean it tonight. Tomorrow's going to be word night. Yeah, I think. I don't know. I think so. I don't know. I like playing the word games, but we'll see how it goes. Anyways, I love you all. Please stay out of trouble. Stay out of Fulton County, more importantly. Stay out of Fulton County. Make sure that you've clocked out for your shift, which means you checked that like button and you made sure that you hit it. And remember that I love you. I'm proud of you. And I'll see you tomorrow. Bye, guys. That lady ordered a vegan pizza and I delivered it to her.